Justices of the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
Good morning, everyone. You may be seated. First case for oral argument today is 691 People v. Coggins.
Good morning, Your Honors. May it please the court. Donald Thompson on behalf of Mr. Coggins. I don't think we have to spend any time on the proposition that the facts in this case are terrible.
Oh, yes.
We can get right by that, but I think, to paraphrase the Court of Appeals, even very bad men are entitled to fair jury instructions. So I'd like to talk about the 3 points in my brief that relate to jury instructions, point 2, point 4, and point 5, unless the court has other ideas. Point 2 is the missing witness instruction. The defense asked for the missing witness instruction after the prosecution did not call one of the cooperating co-defendants who had entered into a cooperation agreement that obligated him to testify for the prosecution if requested to do so.
Okay, counsel, let me just do some housecleaning matter here.
Yes, Judge.
Do we have that decision? Do we have this in the record?
It is in the record, Judge.
The email's in the record, the email decision?
No, I'm sorry. There are two different parts here.
Okay.
There is another email that's not in the record that we're going to talk about in a minute, but the determination is in the record.
Okay.
Here, the request was made for the missing witness instruction, and the court refused to give it. We don't have the analysis as to why the court refused to give it, but I don't think, based on this record, we really need it, because if we look at the arguments of the prosecutor, he argued that the testimony would have been cumulative, but didn't provide any facts from which the court could make that determination. And there was no offer of proof or anything else regarding the co-defendant's testimony. And he also argued that the co-defendant was equally available to the defense, but that's not the test. The test, obviously, is whether he's available to the prosecution and whether he would be in position to provide testimony if requested. Was he in the district attorney's control? I mean, we do have the cooperation agreement in the record that obligates him to testify.
Okay.
So with respect to that point, I'll rest on my brief. With regard to the remaining arguments, moving on, concerning the affirmative defense that was requested by the defendant. This is the one where we do not have the email decision in the record. We had the request by the defense, and there was, this should never happen, but what happened was there were communications after the charge conference, both apparently in person and by email, between the court and between defense counsel and the prosecution. And the court, by its own description, replied to defense counsel that it was going to give the affirmative defense and didn't hit reply all. So the prosecutor never got notification that the affirmative defense was going to be given.
He was willing to give the charge on affirmative defense. He was just going to marshal evidence.
Yeah, he was going to marshal things that weren't in evidence was the problem.
Well, you see, and I think that's what I read in the brief as being the core of the argument was the court was willing to do it, but it was the marshaling of the evidence was the determination made by the attorney based upon that, chose not to.
Yeah, that was the problem. That was why I went through this whole tortured analysis of the dozen times that the defense tried to get the brass knuckles into evidence that were supposedly possessed by a co-defendant and couldn't do it. And then the court's going to marshal the evidence to instruct the jury that one of the co-defendants is armed with brass knuckles. Yeah. And the defense counsel says, hey, wait a minute. I spent the whole trial trying to get these in, and now you're going to tell them? And there is no proof in the evidence, because all of the prosecution's objections were sustained, that anybody possessed brass knuckles during the offense. The other point I'd like to talk about is point 5, the verdict sheet point. This one's kind of interesting because it presents a different factual scenario than what we usually see, I think. Here at the end of the court's instructions to the jury, after he's provided them with the verdict sheet and reviewed it with them, he says, okay, anybody have any objections? And defense counsel says, yeah, I have an objection to a different part of the instructions. And by the way, can I get a copy of the verdict sheet? So, I would anticipate the response by the court would be, hey, the defendant could have fixed it at that point. He could have objected, right? But that's not the test. The test is, did he consent to the submission before it's submitted to the jury? Because if we apply that, and I'm familiar with this court's case in Johnson, where it says, look, you can presume consent if after having an opportunity to review the verdict sheet.
Remain silent.
Yeah, you remain silent, you don't say anything. But think about that for a second, because that would apply to every case where there's a verdict sheet, if that were the test, because certainly during deliberations, defense counsel has an opportunity to see the verdict sheet.
Yeah, but the statute appears, 30-10-20 appears that before the jury retire to deliberate. That's the language that's used by the statute, correct?
That's part of the interesting part too, because the whole thing has been reviewed with the jury. And, what do they do at that point? Say erase, never mind all that stuff I said.
But that's a different issue. I mean, at that point, you make your objection, you preserve it, and the court goes back to square one and starts over again. I mean, that's the whole, when there's cases talk about the silence and the waivers, the fact is that the way I read the cases, and I could be incorrect, is when the jury's gone to deliberate and then the verdict sheet is handed out with it's.
You think it may be, that might be the reading of the case, it's a bright line at that point. Once they go back to the room, there's no fixing the error.
That's what the statute.
Sorry to interrupt. What else could it be? Forgive me. I mean, doesn't there has to be a period of time by which you must object, right?
No, you have to consent. The focus is
By
consent.
which you must object.
Right.
But can your silence be deemed consent?
Right. Well, is your silence in this particular scenario, is your silence consent to the instruction to the jury about what the verdict sheet means and how they should apply it? I think that's the focus here. Okay.
I think we have that.
So unless the court has any other questions, I'll rest on my brief for the remaining points.
Counselor, thank you very much. 693 People v. Davis. Oh, geez. I got it. Okay. You have to look now at these calendars, and we have little bodies, and we have suitcases or briefcases, and then we have Zooms. Morning, Counselor. You have your listed here as argument. I apologize.
Good morning, Your Honor. May it please the court. My name is Jason Schmidt. I'm here on behalf of the respondent people in the appeal. We can address the missing witness rule. Of course, it's the people's position that the defendant had the missing witness Todd statement, the plea minutes, the cooperation deal well beforehand. I think the real issue here is whether Todd's testimony would have been cumulative or it would have supported defendant's version of events. I just want the court to be mindful of the fact that that version of events was raised by Todd. It wasn't supported by the evidence. The evidence was overwhelming. I'm sorry, it was raised by Mr. Coggins. The evidence was overwhelming. There is an application of the harmless error rule. I mean, we can go through the evidence.
I think Counselor kind of recognized that and began his argument that this case is entitled to a fair trial. There's no doubt that the evidence is overwhelming.
That's correct, Judge. If there's any other issues we want to discuss, the affirmative defense, Judge, I just think that a trial judge always has the opportunity to explain to the jurors, the application of the law, and they do that by marshaling the evidence. And I don't think that there was anything inappropriate here by Judge Ward doing that as a way of providing context for the jurors so that they can understand the affirmative defense here. The difficulty here is that when you put it in that context, it certainly gave credence to the people's position that there really wasn't any evidence that would have supported the affirmative defense being offered here as a jury instruction. Judges, if there's nothing further, I'll just rest on the brief.
Thank you, Counselor. Thank you. Let you know too, we also have new screens up here. It's the first time we've used them. Usually I'm used to looking out at these screens out there. Now we have these small screens. I apologize. I'm getting used to the technology.
Thank you, Your Honor.
Now we'll call 693 People v. Tommy Davis. This one is easy, both counsel are present.
Good morning, Your Honors. May it please the court. Pleasure to be here. I'd like to address just a couple of the issues. One, the first point, sufficiency of the evidence with respect to the contention that there was insufficient evidence on the intent to kill element as to the victim Rush. Now, we don't have a depraved indifference theory of prosecution in the indictment. It is intent to kill. And the facts here are that we have a group standing in the middle of a block at night. It's pitch black. I don't think there's any dispute out of that. The shooter is at the end of the block shooting down
And
the
he
block.
shot 5 times into a group of 4, and the DA argued he intended to kill every member of the group by shooting at them multiple times.
You know, I thought about this, and I mean, how is that not either depraved indifference, although very difficult to prove because of the depraved part, and it was elected by the people not to go on the depraved indifference theory or reckless manslaughter. But in terms of it's still, the theory here is intent to kill. And one thing I think you really have to think about is that enough to say under these facts, and it's purely the circumstantial facts, that there is an intent to kill all? The fact of the matter is, it's unknown the intent to kill all, to kill one, to recklessly shoot down the block. And so that's a problem. And we're sufficiency of evidence that it comes to a point where it goes so low that when it becomes speculative, and I submit it's speculative among any of those, there's no way to distinguish here.
Well, Counselor, I beg to differ. You're looking at a case where somebody's pointing a gun at a group of people, and they fire it at the group of people,
Yes.
the people in the group. And you seem to say, well, it took on an element of depravity because it was of the conduct, but he intended from his actions to kill someone. Ultimately, the result was to kill someone with a bullet, and he did.
Judge Venture, I think you're referring also to the people who cited Court of Appeals case Rouse. And it's close, but I would argue distinguishable. And why it's distinguishable, I would say, is that in Rouse, the Court of Appeals said that it was critical, the identification was made by 2 police officers who were present, who saw the shooting. The other critical thing that happened in that case is the court said, the officer said it was well lit. So they could see everything, they saw.
Well, Counselor, here's where I think we differ on that, is we have eyewitnesses here. I know you got into the credibility and the suppression of the identification, but you got eyewitnesses testifying what he did, what the shooter did. And this isn't like pitch, I mean, you know, we can take judicial notice. This wasn't in a closet with the door closed, pitch dark. This was outside. It took place. It was dark out. There's no testimony in the record, at least I saw, and pointed out to me if I missed it, where that it was so dark you couldn't see what he was shooting at.
Well,
They could see him.
That he is down the block, end of the block.
I understand what the facts are, but is there anything in the record to support that it was a shot completely in the dark? I would agree with you. It may take more of the lines of a depravity case if you're going into a dark room where you can't see, you hear voices and you just start firing the gun. But I don't read the record like that. But I'll tell you this, in fairness, I'll take a closer look.
I know you will, Judge Spencer, I know you will. And also sufficiency on the attempted murder of West, and just simply point to 2 facts. West was the one who said, yes, there's return fire when he's shooting at the shooter down the block. But West said, I don't know who he was shooting at, and the shots were going in the ground. So again, intent to kill West, or was it, again, shots back at the group? So argue insufficient evidence there. There's a second point that the court erred when it allowed the prosecution to change the theory of prosecution here. And again, we're talking about the same thing, which is there here the theory that you can intend to kill the group and then someone dies and therefore it's an intent to kill one of the people in the group. What we didn't have here was transferred intent as a theory, and we didn't have depraved indifference. A quick mention of the theory of causation. we have a disinterested bystander who describes an individual as a shooter. She's looking outside her window and she describes him as all in black. That is not a description that West or anyone gave of the shooter, which the few that identified said was Davis. And in that situation, this court in Petrosino, when you have two actors, it creates a burden on the people to prove that the direct cause was the defendant as opposed to the other actor. We submit that there's not enough evidence of that here. Finally, just a quick mention of the consecutive sentence. The contention of Davis is that it was a continuous act, shooting into a group. Even the return fire is shooting into the group, and therefore it should have been a continuous, treated as continuously and a concurrent sentence. If there's ambiguity, he contends that the rule of lenity would have required imposition of concurrent sentences.
Fair enough. Thank you, Counselor.
Thank you.
Good morning.
Good morning, Your Honors. Ken Tyler for the people. I'm prepared to rest on my brief unless the panel has any questions. I would just note for purposes of the consecutive sentencing argument, the actus reus is the pulling of the trigger. I think that's the McKnight case from the Court of Appeals and some other departmental cases. If there's any questions, I'll rest on my brief.
Having none, thank you.
Thank you.
694 People v. Moore. Okay, have you both? Good morning, counselors.
Good morning, Your Honor.
You may begin.
Okay. Good morning, Your Honors, and may it please the court, Sarah Goldfarb on behalf of Mr. Arthur Moore. Repeated prosecutorial misconduct deprived Mr. Moore of a fair trial. Specifically, the prosecutor here opened and closed the trial. Yes.
Ms. Goldfarb, good morning.
Good morning.
This is all unpreserved, correct?
Correct. This is unpreserved, so we would ask the court to exercise its interest of justice abilities and, consider it under those, under that statute.
And if we were to do that, Ms. Goldfarb, as I understand it, you want us to really look at kind of two themes. And if I'm misstating, let me know.
Mm-hmm.
Number one is almost tantamount to calling the defendant a liar or calling the victim a liar, forgive me. And also having to do with sympathy to the jury. There were a couple comments made in closing that seem to support that theory that, okay, she would have to be a magician.
Correct.
And then secondly, this is the time for justice, this is the time to protect her, et cetera, et cetera. That's how I read your brief, as to those two themes. Am I close?
Yes, exactly, Your Honor. And especially as far as the comments made about complainant needing to be not just a liar, but a magician to get that DNA evidence where it was found. That misstates the DNA evidence that was found. It makes it sound like it was conclusively found to be defendant's DNA, and that the only way it could have gotten there was through, sexual intercourse, and that's not true.
Isn't one of the things we're going to have to look at is the defense closing statement said something to the effect of this, the way the victim described the interaction, it was almost physically impossible for it to happen the way she said it was. So wasn't the prosecutor sort of responding to that in terms of the physical impossibility of the interaction? So we should look at that issue?
We can definitely look at that issue. I think as far as it being spatially impossible for the incident to have happened the way complainant testified to, I think specifically defense counsel was talking about the third degree criminal sexual act, that was spatially impossible. I don't know if that argument extended to all of the counts, but at least as far as that comment goes, yes.
Well, go ahead.
Counselor, aren't really, at the end of the day, whether or not these statements are so prejudicial, so egregious, so pervasive, to deny a fair trial. That's the totality of what the argument you're making and we have to look at. And that's the end of it. And then as Justice Kern pointed out, whether or not is it considered fair comment or not fair comment, and whether or not the ones that were not considered fair comment, which I believe is conceded by the DA in some respects, whether or not that rises to the level. That's really the standard for us to look at this on this issue.
Correct, Your Honor. And I would just argue that because this does involve DNA evidence, that testimony by, or those statements by the prosecutor were, particularly egregious in the light of the fact that a lot of lay jurors likely are not as well educated in, how DNA evidence works, and will, very likely could have taken the prosecutor's statements at face value that, this DNA evidence is conclusive evidence that complainant's testimony was correct.
Fair enough.
All right. If there are no other questions, then I would rest on my brief.
Thank you, Counselor.
Morning, Honors. Brad Osler for the people. May it please the court. I would note that I agree, Justice Under. I did concede that the comments made by the prosecutor with respect to protecting the victim or referring to the trial being the time for justice were inappropriate. But I think, given that those comments were very limited in scope, it admittedly was the end of her summation, but it was really just the end. I don't see how that alone can be enough to deny the defendant a fair trial. Very quickly, with regard to the magician comment, I think that was, while somewhat hyperbolic in terms of a choice of word, it was actually not a misrepresentation of the evidence, given that the swabs taken from the victim, one of which was a very, very personal one, it reflected the defendant's DNA, or at least a strong statistical match being present on the victim in a way that would not be consistent with simple sort of physical touching with a hand. So I don't think that those comments were a misrepresentation of the evidence. But overall, I just reiterate that I don't believe the comments were enough to deprive the defendant wholly of a fair trial.
Thank you, Counselor.
Thank you.
Yep.
Thank you.
695, People v. Gutman. Good morning, Counselor.
Good morning.
Yep, you may begin.
May it please the court, Brad Keem for defendant appellant. There are several issues I'd like to argue today, and I'll start with the adjournment issue. The trial court's discretion regarding defense counsel McNellis and appellant's request for an adjournment is construed more narrowly here, where the fundamental right of confrontation is implicated. Defense counsel Quintalone missed the hearing due to a death in the family. There should be no question that death in the family is a compelling ground for.
Counsel, we're talking about the public defender's office here.
Correct.
And so we're not talking about a solo practitioner.
We're not, Judge, but what I would note is defense counsel.
To make a difference?
I think in this particular case, if it was a sentencing or an appearance, it wouldn't make a difference. But here, defense counsel McNellis was provided with thousands of pages of medical records that were essential to this vulnerability hearing the afternoon before the actual hearing. So I think that there was certainly prejudice in that. I mean, defense counsel McNellis said it himself. He conceded that this would leave appellant at a tremendous disadvantage at the hearing. In terms of the evidence, as this court is well aware, we can't just assume an element. The people must prove it. And as relevant here, the people needed to prove mouth to vulva or vagina.
Counselor, can you use circumstantial evidence with the totality of the testimony of the other witnesses and this witness to adequately address the element?
I think it's not unlike age. When this court is faced with, when the prosecutor forgets to prove age, the person may look a certain age, but the people still have to prove it. And here, there's no connect. This is a young girl. What she refers to PP, I think is questionable, especially considering you have the opportunity by the prosecutor to ask BN what she refers to the area as. You ask her mother, ask her grandmother, and if the court wants to not look at it in a sufficiency regard, it can look at it in a weight regard where the aunt says that BN refers to the area as, or to her vagina as her area.
Sir, did you wish to address the lesser included offense issue?
Yes, so the lesser included offense is complicated. You have a continuous course crime of predatory sexual assault, and the theory was based on this continuing course. The judge charged it as such, but what eventually happens is the judge then also charges criminal sexual act in the first degree. And this change in theory deprived defense counsel the opportunity to cross-examine BN about the specific date alleged. You know, an 8-month time period is fine for a continuing course crime, but in a single act crime, there's certainly some litigation that can be done about that issue.
Yeah, but we really don't get to the other argument you have with the 8 months or the time-wise when we're taking a look at the actual whether or not it qualifies as a lesser included. Because there's no doubt with the bill of particulars that it was charged as a continuing course of conduct type crime, which is 2 or more over a period of time. So I understand. What would the remedy be?
So I think the remedy would be that a new trial is ordered, and the only thing that could be alleged would be the single act crime.
Okay, fair enough. I think we have that.
I just also would like to mention briefly the prosecutorial misconduct in that the prosecutor, when he says that he has had the case for 14 months and he implies that he knows more evidence than the jury does. And maybe this court finds that that's not egregious enough. But what I would caution the court and just try to emphasize is I've read another trial where this prosecutor says the exact same thing.
Yeah, there's no doubt. You got our attention on those statements.
Okay, thank you, Your Honor.
Those statements didn't go unnoticed.
Okay, unless there are other questions, I'll rely on my brief.
Thank you, Counsel. Good morning, Counselor.
Good morning. Your Honor, it's Josh Sonner on behalf of the people.
Sir, maybe we could pick up right where we left off.
Okay.
About that comment on summation.
Well,
I read that to basically say to the jury, I know things about this case because I've been dealing with it for 13 months. So keep that in mind when you hear my summation.
and I understand the problem associated with using that wording, except that the district attorney precedes saying anything about that by saying, you are the jurors, you remember, what you saw, what you heard is what controls in this case, and they get a similar instruction.
Oh, I'm sorry.
Yeah. I mean, that the problem is Justice chose by is that so you go out on a limb, you say something that I personally find inappropriate, and then say, okay, judge, you're going to charge you, it's whatever we say is not evidence, so whatever. I mean, there's still a line we have here that we have to keep, and I agree with my colleague that when I said I've had this case for a certain period of time, I know things about this case, implying that there's more evidence we have. We just couldn't get it in for some other reason. For you not to concede that that's a problem gives rise to, I think, what counsel brought up about, is this going to be a continuing course that we're going to get to see where maybe at one point it's going to rise to the level of egregiousness? Well, that's my concern.
In my experience in arguing before this court, when I do believe that something that has been said is inappropriate, I readily agree to it.
So I take it you think that comment was appropriate?
I don't think it's so. I did not think that comment was so egregious because it is preceded by
implying that you have information that might not have been presented, and therefore your summation should be believed. You don't think it's egregious?
I do think that's egregious, but I don't think that's what was said here. I respectfully, Judge, I don't think that's what was.
So I guess the best stance would take that it may not be the best comment that should have been made, maybe shouldn't have been made, but if it was made and we take it the way it was made, it wasn't egregious enough to rise to the level of prosecutorial.
That I would say that as well. And oftentimes because it's not my own cases.
You may hear from us on that.
Yes, and that's, Your Honors, I fully expect that when something inappropriate has been said.
Let's talk about the lesser included.
Sure. I noticed in the defendant's brief, as well as the response to our brief, there was a lot of discussion about the theory of the case. And I don't think the people's theory of the case comes into the calculus of whether or not something's a lesser included offense.
Let's talk about lesser included and the impossibility test.
Sure.
Is that really what we're talking about here?
It would be, Judge.
That here the greater offense is predatory sexual assault. And you base it upon the underlying felony of a course of sexual conduct.
Yes, Judge.
Okay. The lesser included that was charged was criminal sex acts in the first degree. As I look at those statutes, the defendant could have committed predatory sexual assault by engaging in sexual intercourse with the victim, without committing at the same time criminal sex act, which addresses only oral and anal sex. So does it pass the impossibility test here?
I think within because it has, and I believe predatory sexual assault against a child actually has 3 separate lesser included felonies.
Yes, and the one that you relied upon was course of sexual conduct. That's the way you pled the case.
Yes. So I guess if the question of is it an impossibility in all cases for criminal sexual act to be a lesser included offense to predatory sexual assault against a child, I mean, the answer would be no, because there's you have 3 separate lesser included offenses contained within the predatory sexual assault against a child. But as instructed to the jury in this case and under the circumstances of the case, when you eliminate those higher elements that are in predatory sexual assault against a child, it does cover criminal sexual act in the first degree.
Yeah, I find it, I'll be honest with you, I find it kind of, it's probably one of the few parts of statutes that deal with the complication of this is
Yes.
of all crimes. The problem, once again, is we're dealing with the fact that bill particulars, continuing course of conduct, multiple acts over a period of time. And so we have to look at whether or not that issue should have been a lesser included. And obviously, as counsel's indicated, if it shouldn't have been, then there's a restart. I mean, it's probably the remedy.
And understood, Judge, and I would agree. I would just like to.
It's dependent on the indictment, isn't it? Whether it's a lesser included. I mean, don't we have to focus on the indictment, how the case was indicted?
Well, I think it's also, the focus needs to be on the proof as it came in at trial as
Right.
well. If it was an amendment of the indictment, and that's where Mr. Keem in the appellant's brief talks about Vickers. Vickers was an amendment of the indictment. This is just a submission of the lesser included offense for criminal sexual act in the first degree, and it's based on the victim's testimony at trial. The court reviewed the grand jury minutes, the sufficiency of that, albeit it's not.
But it could have been alleviated in the indictment if it had continuing course of conduct or mouth, the vaginal area. I mean, it could have been simply as part of the bill of particulars, could have been, because both of them qualified for predatory.
But and the issue kind of comes back to the first indictment, which was dismissed, where the court, it was charged.
First indictment's out.
Yes.
Let's talk about the second indictment here.
Right, but it matters because in the first indictment, it was charged as a single act crime, and the court found that it's duplicitous because she testified about multiple acts. Her testimony is different from, and again, grand jury is not part of this, but it was.
We recognize the conundrum you were in. It was a conundrum.
I believe that we've addressed the abuse of discretion with the request for the adjournment. I just want to note that Ms. Quintalone, defense counsel had over a week where she knew that she may be unavailable. When Mr. McNellis came to appear on the defendant's behalf at the hearing, I mean, the judge basically had to pull it out of him that he was requesting an adjournment, and he said, I'm prepared to go forward with this hearing. And I think that the defendants also failed to prove any prejudice. I think Mr. McNellis handled that hearing as well as any other attorney would have. So if there are no other questions, I'll rest on our brief.
Thank you, counsel.
Thank you.
Have a good day. 696 People v. Bell.
Your Honors, please the court, Bill Klaus for Tracia Bell. If the court has any questions, I'd be happy to try to answer them, but otherwise I will rest on my brief.
Thank you, Counselor. You're welcome. Morning, Counselor.
Good morning, Your Honor.
Mr. Claus is rested on his brief.
Thank you. Good morning. May it please the court, Leah Mervine on behalf of the people. I would note that in this case, we would ask this court to affirm, and unless there are any questions, the people would rest on our brief as well.
Thank you, Counsel. Thank you both. 697 People v. Addison.
Morning, Your Honors. Kathy Reardon for Jarrell Addison.
Okay, 1 second, Counsel. I think we have Ms. Gray waiting for. There she is. Okay. Good morning, all.
Good morning.
You may begin.
Mr. Addison was convicted of criminal possession of a weapon second, knowingly possessing a loaded firearm. Excuse me. The knowing presumption is permissive, so that can be rejected. With regards to possession of the actual weapon, I'm going to rely on my brief, the weapon that was found in the back seat. What I would like to address is whether this was in fact a loaded weapon. The facts reflect that when the police officers approached, they noted that there was a weapon in the back seat and then a chase ensued after that. When they thereafter searched the vehicle, they ultimately found a small box about 2 by 4 inches of ammunition that was on the passenger seat underneath a gray sweatshirt where the co-defendant sat. So we're submitting to the court that in terms of knowing possession, the proof simply didn't support that this would have been a loaded weapon. If you look at Exhibit 15, that shows.
So wait, are you challenging the constructive possession finding or?
We are.
Okay.
We are. If you look at the exhibits, Exhibit 15 is the one where before it was searched, and you can tell that the sweatshirt is covering it. Exhibit 16 shows after, so that it had been moved. It had been moved by the police and I think by the tech. So prior to that, there was really no indication that Mr. Addison had any knowledge at all that these bullets were inside of that vehicle.
Yeah, the argument is simply this. He may have been aware that there was a gun in there, but he wasn't aware that the gun was loaded.
Exactly, correct. If in fact that's the case, then we are asking this court to consider the lesser included. And at trial, the court ultimately charged the jury with the possession of the firearm, which was the felony. Counsel argued for criminal possession of a weapon fourth, which was.
And the court did charge a lesser included, but not this lesser included.
Not that lesser included.
But he was convicted ultimately of the higher offense.
Exactly, and which is why we're asking this court if in fact it finds that there was not sufficient proof to find that this is a loaded weapon to consider the lesser included of the misdemeanor. As the court's aware, those statutes are identical as far as this situation goes. And as counsel argued, I thought he did a nice job below, taking into account the rule of lenity, you should do this in favor of the defendant so that it would be the misdemeanor that should be considered. One other point, I just wanted to correct something in my brief. On page 24, the co-defendant actually pled in January and provided the affidavit in February, and I think I switched the two of those. I just wanted to alert the court to that.
Thank you.
Thank you.
Great.
Good morning, Your Honors. Lisa Gray. With respect to counsel's argument, the ammunition was found on the front seat passenger of this vehicle, and the defendant was convicted for jointly constructively possessing the loaded firearm. Obviously, you know, the ammunition doesn't have to be in the weapon. We all know that. In this case, it wasn't. It was still legally loaded. The defendant had control of the vehicle. He was driving it. And I don't believe in this case a vehicle presumption was used. But again, two people can jointly constructively possess the firearm and the ammunition. And I would submit that the conviction is certainly not against the weight of the evidence as the facts came out at trial. Unless there are any other questions that people would rely on.
Well, I do have a question, counsel.
Yes.
I'm a little more concerned about point one in the appellant's brief about the suppression motion. I'm concerned by the police officer's conduct and not in their official reports, noting that they received a call from an off-duty officer. I think they, in fact, intentionally concealed that in their official reports. Then they lied about it at the first suppression hearing. When asked what was the basis for them, they said, we're patrolling and we saw traffic. That isn't true. They got a call from the off-duty officer about a gun. When that came out later on the eve of trial, when the tapes revealed, they reopened. And it seems to me the officer are again lying on the stand. They're saying that the off-duty officer, Halfer, who called this in and apparently was pursuing the vehicle for a while until they showed up, they said he wasn't there. He was not part of the pursuit. It seems to me that although I admit primary motivation of the stop of the vehicle doesn't matter, it does seem to me that the police have to be truthful in their official reports, in their testimony. And if they lie, then they haven't met their burden to proceed on a suppression. I mean, on the gun being admitted, and therefore it should be suppressed. Even the ADA at the end of the second reopened suppression hearing admits that the police were deceptive. Don't you have a problem with that?
So I think a couple things, Your Honor. I don't know necessarily that the police officers were actively lying about what they observed at the time of that traffic stop. I think at some point in cases like this, there are other factors and circumstances that lead up to a traffic stop. So from the police officer's perspective, and perhaps this goes to
but they denied getting a call on this car, and that wasn't true. And then they admitted it. And then at the reopened hearing, they acknowledged that one of the reasons they pulled this car over was because the call they received from the off-duty officer about the gun being in the car. Then they said the off-duty officer wasn't around, but the off-duty officer later testified that he was in fact right there when the car went by. He called the police, he followed the car until the police arrived on the scene, and then he peeled off. I don't understand why primary motivation for the stop, if there exists a legitimate traffic stop, a legitimate vehicle and traffic violation, that's true. But isn't the officer's credibility always an issue, particularly in this case when that's all the court has to go on? Shouldn't the court have been aware of the call and the presence of the off-duty officer and what was said? And yet it seems they concealed and lied about it.
The credibility of the officer is always at issue. You're absolutely correct. I guess my recollection of the facts of the first suppression hearing, I guess, are a little different. But at that point, the police officers, they had received information from the off-duty police officer, of course, who had received information from somebody else. That's why, and I think they cleared that up very well at the reopened suppression hearing when they said, "Listen, we had received information from officer." From our fellow officer, but we didn't really know if there was a gun in the car, so we wanted to develop our own probable cause.
But they didn't record the fact in their official reports, 1 2 pages, 1 8 pages. And I just don't think the police get to pick and choose what facts should be presented to the court. when the judge is making an independent, objective determination of the existence of probable cause. I think the credibility of the officer here is seriously undermined.
But I also think that the court did, after the reopened hearing, the court certainly did the right thing. They conducted the Darden hearing. They reopened the hearing. Certainly the defendant.
I'm not saying the court didn't do the right thing. I'm not even saying the DA who admitted that there was deception. I'm saying the police conduct calls into question. We have a plain civil term, frequently falsus in uno. These officers were false any number of times. And therefore, I think the court should have questioned their credibility on the probable cause for the traffic stop. Thank you.
Unless there are any questions, I would go on my brief.
Thank you. Have a good day. 698, People v. Dean.
Morning again.
Morning again. 1 second, let's just make sure we're good. Okay, we're all set.
May it please the court, Bill Klaus for Lamarcus Dean. I'd like to address point 1 first and really focus my comments on point 1 and then briefly touch on points 2 and 4, 2 being the jury selection point and 4 being the sentence. This was an entirely circumstantial case. The trial court erred.
Counsel, didn't Officer Giancurso see the outline of the gun through the shirt? And that's a direct observation. Your attitude is because he couldn't see it because it was under the shirt and he was merely seeing the impression of it or imprint. That makes it circumstantial rather than direct evidence of what he actually saw?
Yes, Your Honor, that's what I'm saying. And I could give you other examples. I was prepared to wear a mask today. It would cover my mouth. I would speak. You would say, Mr. Klaus has a mouth, but it would be circumstantial evidence because you wouldn't have seen my mouth. And that's what this is.
What if we could see the outline of your lips moving up and down?
All that. So
And that makes it circumstantial.
Yes.
Okay.
And
but you understand that assuming we don't buy that argument, then we're back to some direct and circumstantial.
Right.
And the charge would have been appropriate.
Right, and I understand. I mean, that my argument rises or falls on whether or not there was also direct evidence. So, we're not hiding the ball here. Judge, you're right. If you, and I'm reading your faces and body language, if you think that was direct evidence, then I move then to points 2 and point 4. But I think that it's not any more direct evidence than the umbrella with the rain or with the water on it, and the thunder outside. That's circumstantial evidence can be very strong, but it doesn't mean that it's not circumstantial. So maybe you'll give 2 minutes or 20 seconds to rethink this proposition because I think it is circumstantial.
Mr. Klaus, believe me, it will take us longer than that to work through it. It's a good argument.
All right.
I'm just not sure it's winning.
All right, thank you. Point 2, my colleague was a little bit more restrained than me describing the remarks of the court during jury selection as intemperate and better left unsaid. I wasn't quite that restrained, and the problem was it struck me as completely wrong, way over the top, across the line, but it wasn't objected to, and what am I going to do with it? And so what does a defense lawyer do with it? He calls it motive proceedings. I don't know if you're going to reverse on that ground. My guess is that would be a long shot.
Does seem somewhat speculative.
I do wish, though, that somebody's got to call. I mean, if you agree with me that these comments were inappropriate, intemperate, in whatever words you want to use, maybe you could write just a bit about it, the obligation of the court during jury selection, not to humiliate and embarrass and demean people who are there to serve or not serve, as is their right, at least express their opinion. Point 4 of the sentence, we use draconian a lot, but I think a 14-year sentence here is truly draconian. That's 1 year less than the minimum for intentional murder, 1 year less than the minimum for depraved indifference murder. The jury rejected the argument of the prosecutor that he possessed the gun with the intent to use it unlawfully against another. And I think that certainly an appropriate prison sentence is warranted here, but I'd ask you to consider modifying the sentence to something more reasonable than 14 years. Thank you.
Counselor?
Good morning, Your Honors. Lisa Gray for the people. Just with respect to the circumstantial evidence, in this case, any direct evidence, then a circumstantial evidence charge isn't necessary. And there are multiple places in the record, page 181 on Officer Giancurcio's direct. I saw the gun or the weapon in his waistband. The shirt was clinging to Mr. Dean's body, and Giancurcio did not equivocate. He didn't use hedge words. He was very specific that he saw that gun in Mr. Dean's waistband. Even on cross-examination between pages 215 and 217, he says, no, time out. It didn't appear to be. It was what I saw. So, any direct evidence, even if it's not much, is still direct evidence. With respect to the court's comments during jury selection, certainly the court should have been a bit more restrained. I think he was just a little frustrated at that particular juror's almost, sort of snide attitude towards jury service. And this particular judge is very civic minded. And, I think his frustration got the better of him, but I don't think that it denied Mr. Dean a fair trial. And in fact, later on, one of the other jurors said, listen, that other juror, he was coached on what to say to try to get out of jury service. So it certainly didn't have a chilling effect on the other jurors during jury selection in terms of not wanting to be honest or forthright with how they felt. And with respect to Mr. Dean's sentence, a 14-year sentence is certainly appropriate. These are violent crimes. Mr. Dean has a previous gun conviction. He stands convicted of possessing a loaded gun on a particularly busy, crowded day with a lot of people, old people, young people, people who are sober, people who are drunk. And here he is walking through a busy, crowded intersection in the city of Rochester with a loaded gun. I mean, the whole series of events could have gone completely sideways, and thankfully they didn't. So for those reasons, this is an absolutely appropriate sentence, and I would, ask this court to affirm Mr. Dean's conviction and to absolutely affirm his sentence. And unless there are any other questions.
Thank you, Counselor. Thank you, Mr. Clausen. 699, People v. Williams.
Your Honors, this is also my case. I believe I must have checked in before Ms. Clark submitted on her brief. So unless there are any other questions from the bench, I would also rest on my brief.
Thank you, Counselor. Have a nice day.
Thank you too.
700 in the matter of anesthesia, Pete. Counselor, the other two have submitted.
Yes, Judge. May it please the court, Jonathan Choi, the Legal Aid Bureau of Buffalo, attorney for the child. I will submit as well, but before I rest, I would like to make 3 quick points. First, I would like to bring the court's attention to a case that has been decided by this court after our brief was submitted. Second, I would like to update the court as to how well my client's been doing currently. And third, I would like to update the court as to where this case stands procedurally at this time. Thank you, Judge. I would like to turn the court's attention to matter of faith, which was decided by this court on May 7th of this year, citation 143. NYS 3D627. In this case, unrelated parts of this case, the court has provided that the mother's medical record, which established sporadic use of cocaine use throughout pregnancy, in conjunction with her prior demonstrated inability to adequately care for a child, while misusing drugs, provided a sufficient basis to conclude that the subject child was in imminent danger of impairment. So I would ask that this court consider this case in rendering its decision. Second, I would like to update the court on how my client is doing. My client has been in the pre-adoptive foster home for the past 3 years. I would note that despite being in the neonatal intensive care unit since birth for 27 days, my client currently has no impairments. She has no disabilities. In fact, she has exceeded all benchmarks and she's doing extremely well. I would also note that my client currently is not in need of any service. As for the current posture of this case, the appellant has defaulted on the termination of parental rights proceeding on the ground of permanent neglect, and subsequently the permanency hearing was held and the goal is changed to adoption.
Counselor, thank you.
Thank you.
701, in the matter of Brandon I.J. Good morning, counselors. Lost her in the. You got to unmute.
I think I'm unmuted now. I apologize.
You got it. Good morning.
Technical difficulties, of course. Good morning. May it please the court. Bridget Fields on behalf of the respondent, Daisy Davis. I would rest on my brief unless the court has any questions on any of the points raised therein.
Having none, thank you, counselor.
Thank you.
Good morning. Morning.
The only comment that I want to make, other than what I've put forth in my brief on behalf of the department, is that this child has been in foster care since January of 2017. He has been with the same foster parent since June of 2017. That parent is ready, willing, and able to proceed forward with adoption immediately. During that period of time, because of the appellant's willful conduct in this case, as I think I exhaustively put forth in my brief, the child never went back to reside with her or even had any kind of unsupervised or unmonitored visitation. That child is thriving where he is currently. And I believe that the court should affirm what the lower court did here as far as terminating the appellant's parental rights. Otherwise, Judge, Your Honors, I would rest on my brief unless there are any questions that anyone has to ask here.
Thank you, Counselor.
Thank you.
Morning.
Good morning. May it please the court, Elizabeth Moeller on behalf of the Legal Aid Society for the Subject Child. I would echo Mr. Bell's points that my client is 5 years old. He's been in care since 2017. He's never been returned to mom. And I would note in this, just specifically addressing the point of the suspended judgment, I think family court made the correct determination here. Mom tried to demonstrate she was stable because she was staying with her sister. She was getting things together, but I think the testimony actually indicated that she was, between a couple of sisters and maybe a hotel, and it just continued the pattern of her not having a stable residence, which is one of the things family court relied on in not issuing the suspended judgment. Furthermore, family court relied on the fact that in the Catholic Family Services records, Exhibit F in this matter, that those practitioners found that mom was unable to maintain sobriety outside of a structured environment, which I think, she had a significant alcohol problem in addition to using marijuana. I think although there were periods where she was sober, she wasn't able to maintain that outside of living in a structured living environment. And so clearly, I think she should not have been given that brief time to try to have the suspended judgment to get Brandon back in her care. It's in my client's best interest to be adopted at this time by the foster family he's been living with for the large majority of his life.
Thank you, Counselor.
Thank you.
For coming. 703, 704, Kavanaugh v. Kavanaugh. Justice Kern is recused There's new terminology. Let's see what we have here. We have 3 present and 2 on Zoom. Okay, Mr. Dolores there. Okay, it appears from what I see, everyone is here, all 5 counsel, 2 on Zoom, 3 present. Ms. Carlin, you may begin.
Thank you, Your Honor. May it please the court, Hugh Carlin on behalf of the plaintiff appellants. This morning, I want to briefly address there's 2 companies involved here, CavCon and Consumers. I first want to address CavCon. First point is special term correctly determined that the operating agreement does not permit the subject transfers that are at issue in this lawsuit.
Counsel, do either the 2017 complaint or the 2019 complaint accuse the corporate entities of doing anything wrong?
The corporate entities themselves? No, Judge. The corporate entities are, in our view, passive parties. That the relationship between the members in CavCon is determined by the operating agreement. And when it was put in place in year 2000, it was with 7 equal ownership shares.
But there's no claim that they did anything wrong. No relief is being sought against them.
Against the companies, Judge? No, there's no relief being sought against the companies. I believe the companies would have to abide a decision that says if the decision.
That's why they could be considered nominal parties.
Yes, Your Honor.
They're named, but they're not named in the 2017. And if the transfers are voided as of 2017, who cares whether the defendants are in the 2019? Once the transaction's rescinded, it's rescinded.
That's correct, Your Honor.
Okay.
That's correct. And I believe the language is so clear, Judge. It's as clear as a bell. No transfer, except as provided in section 10.2, would be valid. Okay.
Well, that issue, Judge Nowak apparently said you met your burden on that issue.
That's correct,
and
Judge.
The issue is a hearing on the affirmative defenses of waiver and estoppel.
And so, Judge,
please don't spend time on that.
So let me move right to the affirmative defenses of waiver and estoppel in connection with CavCon, Your Honor. Okay. It's undisputed. There's no express waiver. So what must they do? They tried to point to prior transactions. There are no prior transactions involving CavCon.
So you say CavCon can't be bound by CBI agreement not being enforced. It's a separate legal entity.
That's correct, Your Honor. It cannot be bound by actions of consumers, and it cannot be bound by actions of the partners of South Park, Your Honor, which is the other bootstrap argument that's been offered here.
Yes, but that argument's been offered by the corporations, but if they're just nominal parties, who cares what they allege? It's not appropriate for us to consider, as I understand it. And Neil doesn't make that direct allegation. He says, I join in that argument, but he's made no written motion on that issue.
That's correct, Your Honor.
Okay.
That's correct.
I understand that.
And Judge, looking at the operating agreement, there's a merger clause there. So that would preclude any reliance on prior acts under a prior agreement. It's a merger clause. And Judge, I would also point out that the members of CavCon are only siblings. Larry Sr., the father, he has never been a member of CavCon, unlike the partnership. Now, Judge, I would submit that because you've got 7 volumes of record in front of you, it's no easy task, and it was no easy task for Justice Nowak. So all of my comments are due deference and respect to Justice Nowak.
Counsel, I'm just wondering what happens next. If we end up buying your argument that there is no need for a hearing on waiver and estoppel, what happens?
Your Honor, at that point, with respect to CavCon, the transactions are deemed null and void. And therefore, we have 7 equal members. And the true rights that were stripped from my clients will be back in place. They can decide, is Neil Kavanaugh an appropriate manager for CavCon or not?
So it's corporate governance issues, and it
Absolutely,
has nothing
Your
to do
Honor.
with these contracts.
That's correct. We will move forward with the contract rights that all 7 parties agreed to under the operating agreement, Your Honor. That's correct. I'm happy to discuss the South Park agreement. Again, all the transactions that they raised have nothing to do with CavCon, Your Honor. Turning then to, if there's no questions on CavCon, I'd like to just quickly remark on consumers. Again, Judge Nowak got it right, okay? This agreement does not permit these transfers. If they wanted to transfer, they could have all amended the stock purchase agreement for these transfers.
I read the record. I don't think anyone really disputes that. There's a defense, but no one is saying that the agreement was not violated.
That's correct. That's correct, Judge. They're saying that, they're arguing that,
we've
these
always
things that
talked this way.
happened 15 or 20 years ago somehow gave Neil this level of comfort that he could do it. And I just point out to the court that their prior corporate counsel warned Neil. He said, the agreements don't provide this. The best thing to do is go get the shareholders' consent.
But
And he ignored that.
When we boil it down, it goes to almost the same issue as CavCon. Do we have a waiver or estoppel type argument? I mean, right?
That's correct, Your Honor.
That's really what it boils down. Once we say we've got an agreement. And the way I look at it is there's three categories. There's the categories of the bulk of 70-some whatever transfers. Then there's the category involving the stepmom. And then there's the category involving
There was a brother, John, Mark.
30, so, which, there's the bulk of it is one that involved the father, the principal.
Correct.
And then there was the stepmom, and then there was Mark. So the argument appears to be that because of all that taking place, why doesn't that result in a question of fact on whether or not there's a waiver?
And I think the answer, Your Honor, is as a matter of law, no. As to the principal transferring,
those were permissible.
Those are permissible. Those are expressly permissible. And the argument that principal and shareholder are subsumed, the
And that's
plain
61 of the
reading-
73.
Yeah, that's correct, Judge. Okay. And the principal is distinct from the shareholders. And if you read the agreement, it's very clear that it was intended to be. So that leaves but three transactions. The one from Zeta to the siblings, or to Larry Sr.'s children, and the one to Mark. I would submit that those actions that occur in 1997, 96, and 95 would not be a basis that a reasonable jury could find waiver for an event that occurs in 2012 and 2013. It is so remote, no reasonable jury, no reasonable fact finder would find that as a matter of law.
Are you conceding that Zeta's transfers were impermissible?
No, I'm not. I believe that that's still part of the principal's shares being transferred, okay?
So really the only violative transfers would be Mark's.
Yes.
And there were, I think, 4 of them, right?
There were 4 of them all at once, Your Honor. And the record's very clear that all 4 that received pieces of Mark's shares did so at Dad's behest. So everybody knew Mark was in trouble. He was in financial trouble. They didn't want an outside creditor getting hold of shares in consumers. Dad said, you're going to sell, he's going to sell them.
But you're saying those transactions 18 years ago did not act as a prospective waiver on this condition.
That's correct, Your Honor. 18 years is far too remote to suggest that these types of transactions deliberately concealed from all of the shareholders could somehow serve as a waiver. Your Honor, unless there's further questions, I'll rely on my brief.
Thank you, Counsel.
Thank you very much.
Mr. Doyle, I have next. Good morning.
Yes. May it please the court. I'm Vincent Doyle. I represent Neil Kavanaugh in both actions. The plaintiffs would have the court believe that their interpretation of the 2 agreements is indisputable. What is truly indisputable is the evidence before the court that all of the Kavanaughs, including the plaintiffs and the defendants, acted as if the agreements allowed intrafamily transfers without any of the formalities that the plaintiffs now insist on. The evidence is equally indisputable that all of the Kavanaughs, including the plaintiffs and the defendants, participated in intrafamily transfers.
Okay, Mr.
and
Doyle,
benefited
Mr.
from
Doyle,
intrafamily transfers.
let me interrupt 1 second, because I try to put things in compartments so I can keep them separated. I found this a little confusing. It seems the arguments you're making really go to the affirmative defenses?
Well, Your Honor, in our opinion, they go both to the affirmative defenses and also to how the contract should be interpreted.
Well, let me ask you this question. Shouldn't the contract be interpreted the way it reads if it's plain and on the four corners of the conduct? Are we bound by the construction of it? And if we do find that they are bound by it, then obviously the next step is what you're saying is we look at the affirmative defenses.
Mr. Doyle, I'm just confused. Did you, on behalf of Neil, file any written notice of motion or cross motion seeking summary judgment dismissing claims against Neil in either the 2017 or the 2019 lawsuit?
Your Honor, at oral argument, it's reflected in the transcript.
The question was, Mr. Doyle, did you submit any written notice of cross motion?
We did not submit a written notice of cross motion. At the hearing, the transcript, we requested the judge's permission to join in the cross motion, and he granted that. Judge Noack granted that, and his ruling reflects that. His ruling reflects that we had joined in that cross motion. Judge Sentra, to go back to your question, I think you accurately stated the principle of law of contract interpretation. We argue in our brief, and we did below, and we argue currently in the brief, that the interpretation that the plaintiffs are urging is contrary to the intent of the agreement, contrary to the language of the agreement.
I thought Neil's position was you were just going to argue that there was waiver and estoppel. I didn't think there was an assertion before us that Judge Noack's determination on the underlying issue where he found the plaintiffs in both actions met their burden. The issue that you were wishing and that Judge Noack felt should be heard is whether there's waiver and estoppel. You're saying you're also contesting whether his determination about the transactions violating the agreement is before us?
Yes, Your Honor. I believe our brief and our reply brief clearly lay out that our argument is both, is that the interpretation that the plaintiffs urge of both contracts is incorrect, and also that the evidence established waiver and estoppel as affirmative defenses. And that was the burden of the plaintiff on their motion for summary judgment, was to establish that their interpretation was correct as a matter of law, and there were no issues of fact that could be raised about that. And also, their burden was to establish that there was no issue of fact as to any affirmative defenses. I believe, Judge, below and in our briefs, we clearly argued both points. Now, in terms of the interpretation, it is clear from the testimony that was submitted, the evidence that was submitted, and the language of the contracts themselves, that the intent of the agreements was to keep the shares within the Kavanaugh family. That is, in fact, if you look at the preamble to the consumer share purchase agreement, it's stated in there. If you look at Neil's testimony, he stated that. If you look at the testimony, the affidavit of attorney Paul Como, who prepared the agreements, he also testified at record 3829. He also affirmed that it was the intention of the agreements to restrict transfers to third parties, but to keep the shares within the family. In addition, so the interpretation that the plaintiffs urge is contrary to that intent by making it harder to transfer among family members than it is to transfer to third parties. In fact, according to the interpretation that the plaintiffs urge, it would be impossible under the share purchase agreement to transfer shares between family members of consumers, and impossible under the operating agreement. It's certainly much easier to transfer to third parties. Also, the agreement, the interpretation urged is by the plaintiff is contrary to how the parties acted consistently in the decades since the agreements were signed. Now, the plaintiff has attempted to minimize the number of transactions that we're talking about by grouping them into certain categories. And you can look at them categories, but if you look at them overall, it's 70 different transactions over decades of time since the agreements were signed. And there were transactions, and there is evidence in the record of transactions regarding consumers and Cavcon. It's not limited to consumers, as was just argued by plaintiff's attorney. There is evidence in Mr. Como's affidavit that shares of the real estate company were also transferred. Now, as to the different groups, there can be no argument that the transfers of Mark Kavanaugh shares clearly violated the interpretation of the agreement that is urged by plaintiff. There's just no argument otherwise. The plaintiff's counsel says, well, he was on the verge of going bankrupt. Well, okay, that's perfectly fine. Martha Kavanaugh, in her emails that are submitted to the court, indicated she was in financial trouble as well. But the agreements don't say anything about financial trouble justifying some process that's not laid out. So the Mark Kavanaugh clearly violated. The transfers from Zita, the second wife of Lawrence Kavanaugh, those transfers also clearly violate plaintiff's interpretations of the agreements. And I wrote down what Mr. Carlin just said when he was asked about that. He said, well, Zita's transfers, they were all of the principal shares. In other words, Lawrence Kavanaugh Sr. shares. So that somehow makes it all right. Well, in that regard, so were Martha's shares, so were Mary Ellen's shares. Everyone got their shares from Lawrence Kavanaugh. If somehow the fact that they came from Lawrence Kavanaugh originally exempts them from the strict technicalities that plaintiffs now urge, then none of the shares are subject to those. That's simply an argument that they came up with to try to distinguish, and in fact, they can't distinguish Zita's transfers. So if you look at Zita's and Mark's transfers alone, there are more than a dozen transfers of shares that were conducted. And quite simply, our argument is, if you look at the intention of the agreement, undisputed, if you look at how the agreement was handled and considered by the parties, including plaintiffs here, how can you say the agreement should be interpreted some other way? From the moment the SPA was signed in the decades since, the Kavanaugh families freely transferred shares among themselves without ever claiming any contract precluded it or required any formality. And the attorneys who wrote the agreements, Mr. Cuomo and his firm, facilitated these transfers. They prepared the documents that allowed the transfers to happen. So how can we say as a matter of law that the attorneys violated the agreement they wrote themselves in facilitating these transfers without any of the formalities? The plaintiff's interpretation is contrary to the intent of the agreement, will result in absurd results, and is belied by the behavior of the parties. And those are the traditional principles of contract interpretations, Justice Sentra. On that basis, plaintiff was not entitled to summary judgment. And plaintiff was also not entitled to summary judgment for a second reason. It's because they did not meet their burden to establish that the affirmative defenses did not apply. The trial court actually found that Neil, quote, had demonstrated that he reasonably relied on the lack of enforcement by his siblings in accepting his sister's ownership interests, and that plaintiffs waived a known right by previously accepting shares of stock without complying with the same contractual provision. That was his finding. And on that basis, we asked the court to affirm the trial court's denial of summary judgment to the plaintiffs.
Thank you, Counselor. Okay. Mr. Garvey?
May it please the court. Good morning. I represent Mary Ellen Kavanaugh. She is nominally defendant here. However, she's standing on all four with the argument that Mr. Carlin made. So I'm not going to add anything more to that. If there was anything else that you were particularly interested in,
No, I would just like to say I commend you for, I believe you've got the procedural steps right, and I commend you for that.
Thank you so much.
I'm not sure everybody else did.
Thank you, Counselor.
Anything else?
Thank you very much.
Thank you.
Okay. Milbrain, Mr. Milbrain.
Good morning,
Morning,
Your Honors. May it please the court. I'm kind of putting aside what I had planned to say because Justice Niemeyer asked a very poignant question. Does it matter to the companies? I'm the companies. Yes, it matters. Membership.
So what are you being accused of doing in the contract claims? What did they say you violated?
transferring the shares. I have to transfer the shares. The company has to transfer the shares. The shares, by the way.
But they're not saying you didn't file the agreement. They're saying Neil didn't file the agreement. And therefore, the transfer of the shares from Mary Ellen and Martha should be voided. It's not saying the corporation did anything wrong.
I agree, Your Honor.
And you're not even in the 2017.
I'm not. And
if the 2017 remedy is to vacate, then it's vacated. You don't get to say, well, but not in the 2019 litigation.
Or if the remedy in the 2017 is to honor the transfers, then they're honored.
Okay, that's what I thought.
So it is a bit confusing. Defendants are really plaintiffs. Plaintiffs are really defendants. It does get convoluted, right? And I think I follow procedure.
That much I have to agree with that.
So I was saying membership has its privileges. If you're a Kavanaugh child, a shareholder in this corporation, different rules apply to you. If you walk in this courtroom with your vaccine, different rules apply. I don't have to wear a mask. That's how the world works. We break people into subgroups and give different privileges based on something. I've read these agreements 4,326 times. I cannot find a single sentence that says member to member transfers are restricted. Shareholder to shareholder transfers
You're
are
saying
restricted.
the agreement silence creates an ambiguity, but that's not what Justice Nowak found.
I agree with what you just said, Your Honor.
Okay.
So reading the agreements, and sometimes those little lights go off in your head. Reading the agreements as late as last night, I'm thinking, it doesn't even mention shareholder to shareholder transfers. Why doesn't it even mention shareholder to shareholder transfers? Oh, that's right. It's only restricted. If you take real plaintiff's argument, then the agreements should have said all transfers are restricted. It shouldn't have said a bona fide offer from a third party. From a third party is incredibly important because that's the only restriction. To a non-member, incredibly important. That's the only restriction. If they didn't mean to restrict just those two classes of people, it would have said all transfers are restricted. Those clauses would not have been in there. And oddly enough, my former partner, Paul Como, agrees with that, and he wrote the agreements with help from various others at Hodgson Russ. If I'm not correct on that, and I believe I'm correct on that, if I'm not correct on that, waiver and estoppel absolutely apply. And why does it matter to me as the corporation, as counsel for the corporation? Because I want an orderly transfer. I want no fighting amongst the shareholders. I want the corporation to flourish and everybody to be fair with each other. And when I look at the agreements that Martha and Mary Ellen signed, defendants Martha and Mary Ellen signed, there's warranties in there saying that I have the ability to transfer these shares. Why do they have the ability? Because they're Kavanaugh's and they're current shareholders, and they're transferring them to.
Yeah, sir, maybe I missed something, but I didn't see anybody taking issue with the fact that the agreement was violated.
The agreement was,
That the agreement was violated by these transfers. No one seems to be taking issue with that.
I think that the agreement was not violated by these transfers. I don't think
But no one has said that.
my very first point in my brief.
No, I mean,
But I don't understand why you have standing to bring a point as the corporation. But I had asked this question to Mr. Doyle about Neil's opposition papers, and they argued only in response to Matthew's motion that there should be a hearing because of the issue regarding waiver and estoppel. And that's at, as I understand it, record 646 to 649. So I thought that part was conceded, and we're here as to whether Judge Nowak's determination as to whether there's waiver and estoppel and the need for a hearing, and you say there is.
Well, I say there's no need for a hearing, but he should have established and granted our summary judgment motion on waiver and estoppel. But at the bare minimum, there's a need for a hearing. So, Your Honor, my first point in the brief is the Supreme Court erred when it found that the agreement.
Well, you weren't even named in one lawsuit, were you?
Correct. I was not named in one lawsuit. but I'm necessary. You know, the corporation doesn't exist without the corporation. But turning to
But nobody's claiming you did anything wrong
they're
in the
claiming
complaints that I've seen.
they're claiming that the corporation transferred these shares when they shouldn't have.
No, they claim, as I understand it, that Neil bought the shares when he should not have, and that he contracted with Martha and Mary Ellen in violation of the exemptions. Wasn't saying the corporation did anything wrong, but that's my reading of it. You're entitled to tell us what yours is.
Your point is, I suppose, that there's an implicit argument that the corporations did something wrong because the transfers can't happen without your action.
That is exactly it, Your Honor. And by the way, we're a defendant in the second suit. So we're here. Turning to the waiver and estoppel. And not to jump exactly on the argument that Mr. Doyle made, but what Mr. Carlin said, and I think what Justice Peredato kind of agreed with is, well, they were founders' shares. The Larry Sr.
Principal shares.
Or principal shares. The Larry Sr. transferred to Zita, his second wife. And by the way, it was right after they got married. So he did that for a reason, I believe. To his second wife, those still had the halo of principal shares. But it couldn't have. When it becomes owned, by the way, that transfer, if Larry Sr. was just a shareholder, would have been violative of this agreement because it was to a third party. Because she wasn't a previous shareholder or member. So that transfer goes through. Those shares, which on the back say are restricted by an agreement, and you're supposed to go look at the agreement, but those shares, once Zita held them, were no longer principal shares. Just as Neil's shares, Mark's shares, all the children's shares, when they were transferred to them, they moved out of one subgroup of people to another subgroup of people and became regular shares. So the Zita to children transfers, shareholder to shareholder, by their reading, violated. You can't do that under this agreement. The Mark to chosen children transfers, not all of them, absolutely violative. Can't do it under this agreement. And those were the only prior transfers. Yes, there's a period of time, but those are the only prior transfers. So you have to think, why do Martha and Mary Ellen say that they can transfer and say that they don't have to tell everybody? By the way, everybody knew to some extent, but they say they don't have to tell anybody. And the onus is on the purchaser, by the way, right? No, it's on the seller to tell everybody, because the purchaser is a third party, doesn't know who everybody is. So Martha and Mary Ellen, when they sell their shares to Neil, promise that they have marketable title. Why do they think they have marketable title? Well, it's how we've always done it. It's absolutely how we've always done it.
And now they're saying, wait, we were wrong.
By seller's remorse.
Okay, I think I got that.
Your Honors, unless there's any other questions.
Having none, thank you, Counsel.
Thank you.
Last but not least, right?
Good morning, Your Honors. Jeremy Scher for Martha Kavanaugh. My brief only addressed the CavCon transfers, and so I will only address those transfers now.
Counsel, I just had the same question for you that I've had for others. You never filed any written notice of cross motion or motion seeking affirmative relief in either the 2017 or 2019 lawsuit. Isn't that correct?
That's correct. We were cross moved against.
Okay, thank you.
Then we joined. But yes, that's correct. We filed an affirmation joining in the plaintiff's motion, and as I just said, we were cross moved against. So we are non-movements with respect to both motions, but we responded to the cross motion by the corporations and Neil. So I'll be brief. Contrary to counsel for Neil Kavanaugh's representation, there were never any transfers of the CavCon membership interests prior to the Mary Ellen and Martha transfers, period. There were none. There were the last inter-sibling transfer of CavCon of interests that could be even associated with CavCon were South Park partnership interest transfers in 1995. So more than 12 years before, more than 17 years before the Mary Ellen transfers and more than 18 years before the Martha Kavanaugh transfers. Critically, in between 1995 and the Mary Ellen and Martha transfers, there was a new agreement, the CavCon operating agreement, which expressly superseded and replaced the South Park agreement. So as Mr. Carlin said, when parties enter into a brand new agreement with a merger clause, a no waiver clause, and written restrictions on transfers, earlier acts that can be potentially described as waiver of an old superseded agreement cannot be used as evidence of waiver of the new agreement. Doing so would read out of existence the no waiver and merger clauses. Otherwise, I'm prepared to rest on records.
Thank you, Counselor. Thank you all. Have a nice day.
Thank you, Your Honor.
705 Capel v. WHEC TV.
May it please the court. My name is Tom Ricotta. I represent.
Hold on one second. Okay. I just wanted to make sure your opponent was online, but it looks like he is. So you may proceed, Mr. Ricotta.
Thank you, Your Honor. We filed this appeal, as the court is well aware, arguing that the lower court overreached in terms of the decision to grant a motion to dismiss on behalf of the defendant, Mr. Capel's former employer. There were two claims. There's a breach of contract claim and there's a defamation claim that I'll talk about. I'll start with the breach of contract claim.
Mr. Ricotta, on your first point, the breach of contract claim, as I read your brief, what you want us to look at is whether the court acted properly in the CPLR 3211A7 context, or did it make factual determinations, right?
Absolutely, Your Honor. The court on page 4 of its decision found as a matter of law. It wasn't even really finding it as a matter of law, it was finding it as a matter of fact. That
What I didn't see in your brief, Mr. Ricotta, maybe it's there and I missed it, but are you saying that uttering a racial slur is not conduct detrimental to the station and is an action taken with due regard for public morals and conventions?
So what I'm saying is twofold, Your Honor. Number one, reading the pleadings and accepting the fact set forth in the pleadings as true, as the court should have. The facts are not that Mr. Capel uttered a racial slur. The fact that Mr. Capel had linguistics error. Saying a racial slur and flubbing two words and having them meshed together are two very different things. And they're very important from the standpoint of...
Counsel, I'm not sure I agree with you. If I say the words and they can be interpreted by anybody listening to them as a racial slur, I don't understand the distinction you're trying to draw. There's no question he said those words. You're not disputing that. You're just saying, what was the intent behind it? I'm unsure intent mattered in this situation.
Well, so what I'm saying, Your Honor, what effectively happened, and it's essentially science, is that he, in speaking fast, he merged two words together. And had he not cut himself off and finished, he would have said "punya," instead, as has happened numerous times historically, the same exact.
No, but the point is, it may not matter in terms of whether there's harm to the station. He actually conceded that this error could have been perceived by the public to be a racial slur. Whether he intended it or not, as Justice Nemoyer has stated, is may not matter.
But I think that's where the actual terms of the agreement do matter, because the agreement requires termination for cause where Mr. Capel engages in conduct detrimental to the station, its business, its employers, or conduct that reflects a lack of due regard for morals and conventions. Now, the second...
Mr. Ricotta, that gets back to my initial question. I thought essentially your client has conceded that the words as they came out could reasonably be interpreted as a racial slur. Taking that as true, are you saying that uttering a racial slur on live TV like that is not conduct detrimental to the station. Is that your argument?
I think that obviously if someone intentionally went on air and uttered a racial slur, that could be detrimental. However, what I would say is in this case, based on the facts that are before the court, there was not an intent. And that's where I think intent does matter, because they're required.
Where are you coming up with this idea that intent matters? I don't see it in the employment agreement.
Well, the employment agreement indicates if he engages in conduct detrimental to WHEC. The conduct he engaged in
Look, engaging in conduct doesn't have to involve intent. It could be kind of accidental conduct, which is what you claim happened here.
But even then, Your Honor, with all due respect, at that point, they would have to be able to present, which they can't on a motion to dismiss, some evidence or proof of detriment, especially when the facts before the court are that this was.
You just wait. You just admitted to us that the conduct of engaging in a racial slur on air is detrimental would be detrimental to the station. So
let me be clear. I don't think that on a motion to dismiss, simply by saying that someone had a linguistics error on air, that the station can, for the purpose of a motion to dismiss, establish factual evidence and proof that they were harmed. I don't think that it can be said in every situation that if someone says something that can be.
We're not talking about every situation. We're talking about this case and this situation. And in order for us to agree with you, we would have to conclude that the utterance of a racial slur on air, that there's some question that the utterance of a racial slur on air is not detrimental to the station.
Well, but that's where I think there's a distinction. And I understand that there's sort of a needle that needs to be threaded, but I think it's an important needle that needs to be threaded by the court. Because when we're saying that there was an utterance of a racial slur, what we're doing is we're making a factual conclusion when the science behind what actually happened is that there wasn't a racial slur uttered. There was a sound made because two words were blended. And that's important, because that is a real distinction here. And frankly, the station was aware of that when they made their decision to terminate him, because they met with him, as the complaint sets forth, 2 days later, and made him aware of this. And this was the first time he was hearing of it. He offered to go.
I know it's tough with the Zoom. Don't worry about it. But let's take us to the defamation claim, just to kind of summarize. I don't mean to cut you off in any respect, but as I understand in defamation, you're essentially saying that the Second Amendment complaint that you proposed cured whatever pleading deficiencies may have existed with the earlier pleadings, correct?
Absolutely, Your Honor. I think the Second Amendment complaint sets forth the specific statements made by Mr. Reingold, and the pleading sufficiently set forth that those statements were knowingly. Mr. Reingold met with my client the day prior. He knew that my client did not intend to make any sort of improper statement, was unaware of it, was shocked by it, and offered to speak out and apologize for it. He was sidelined and told, no, we'll look into this. You just wait. Don't post anything. Don't do anything. Don't say anything. And then they fired him, and he went on air and basically said he's fired because he uttered a racial slur and didn't apologize for it. I mean, he knew at that time that what he was saying was not only untrue, but was going to paint Jeremy in a very negative light, that he knew he'd done something and was unapologetic for it.
Mr. Ricardo, my last question is, if I understand it correctly, you do not dispute that your client was a public figure, correct?
I don't dispute that, Your Honor, but I think that notwithstanding him being a public figure, I think the defamation can speak for the reasons in our brief. I won't go into it. But I do just want to circle back with whatever time I have left to the breach of contract, because I do think that.
I think we have that argument, Counsel. We understand it.
Okay, thank you.
Counselor, Mr. Thomas.
Thank you. May it please the court. Look, this is, I think, a very simple case. A word that none of us is willing to say today, and that plaintiff's counsel was not willing to put in their papers, came out of his client's mouth. There's no denying that. You can see it. It's well documented. And as soon as that happened, the detriment just absolutely crushed Channel 10. That provided that, and that's in the complaint. the detrimental information that flowed into Channel 10 is within the four corners of the complaint, and we parse them out at page 9 of our brief. The bottom line is the words came out of his mouth. It was a horrible detriment. He was capable of being fired on the spot. That's what they chose to do. End of story. And in terms of the defamation claim, it is woefully insufficient. And unless the court has any questions that it wants to ask me, I'm going to rest on my papers.
Thank you, Counsel. Thank you both. Have a good day.
Thank you.
706-707 AH Wines, Inc. v. C6 Capital Funding, LLC.
Your Honor, Catherine McGovern is audio only.
Okay. Morning, Counselor. Mr. Boxer, can you hear me?
Yes, good morning, Your Honor. Sorry, I was just unmuting myself.
No problem. Did you hear that Ms. McGovern is going to be audio only? Okay.
I did, thank you. Thank you. May it please the court, I'm Jeffrey Boxer, representing the appellant C6 Capital. As outlined in our briefs, we believe the court below abused its discretion in granting a preliminary injunction prohibiting.
Mr. Boxer?
Yes, sir.
Let's get right to the issue that concerns me the most. I mean, I realize there's a lot of case law going on in the state of New York regarding this, these types of arrangements, right? So we've seen that, we've read those, et cetera. But I'd like you to take me to the irreparable harm. Where is there clear and convincing evidence of irreparable harm in this situation, given the fact that the subject of the action appears to be effectively a debt?
Yeah, certainly we agree with that, Your Honor. We don't think that the plaintiffs below were able to demonstrate any type of irreparable harm, because what is at issue here is simply money. It is a judgment for money only. If it was improvidently granted or if it is collected improperly, it is capable of being returned easily. And the plaintiffs did not meet their burden of showing irreparable harm below. There was some argument that they might lose goodwill of clients if the...
Well, let's focus on that, Mr. Boxer. Wouldn't that be the argument in almost any case involving a debtor that can't afford to repay the debt? And it's saying, hey, if you collect the debt that I might owe you, I'm going to go out of business. How is that?
Exactly, Your Honor. We don't think the plaintiff's argument that there's a loss of goodwill by enforcement of a debt or enforcement of a judgment against it holds much water for that exact reason. Anybody who owes a debt or owes money to someone could conceivably make that argument. The fact that you have to pay someone money back cannot in and of itself mean that there's irreparable harm, because you risk loss of goodwill if you actually pay the money you owe back. So we don't think that irreparable harm was demonstrated. We don't think that the argument plaintiffs made below relating to potential loss of goodwill is viable. We also don't think they met their burden, even if it was viable, of showing by any stretch of the imagination, much less any actual evidence, that there was a real risk of loss of goodwill here.
So I have a question for you, sir. You mentioned in your brief that there is no recognized affirmative claim for usury. Was that issue before the court below?
So it was not. The argument in our appellate brief regarding the corporate defendant's inability to bring a usury defense was not raised below. It was raised in our appellate brief. The plaintiffs' respondents responded to it. They had an opportunity to contest it. To the extent that is an issue, we do ask that the court would exercise its discretion to address that issue. And I would refer the court to Capretto versus City of Buffalo, 124 AD 3rd, 1304 from this department, that lays out the grounds on which the court can do so. But we would emphasize that there was no prejudice to the plaintiffs' respondents here, because they did have a full opportunity on appeal to address that, and did in fact in their brief address it. We would also refer the court to the Paycation case, which we cite in our papers, a very recent decision from the Second Department, which is a virtually identical situation to the one.
It's right on point.
Yeah.
Okay, counsel, thank you.
Thank you.
Ms. McGovern?
Yes, Good morning, Your Honors. May it please the court. I'm appearing on behalf of the plaintiffs in this instance.
Counsel, I have a question for you. Ordinarily, when the court grants a preliminary injunction, when the trial court does, they're required under circumstances such as this to direct the payment of an undertaking. That was not done here. If we were to affirm the court, there is authority for us to require the trial court to fix an undertaking. Are your clients prepared to meet that obligation if it's imposed upon them?
Well, Your Honor, really there's only one defendant here, A.H. Wines. The other named defendants were just added onto the agreement by the defendant, C6, as almost like a guarantee of repayment. These plaintiffs were not a party to the underlying agreement. Their receivables could not be part of any of the consideration. It was only A.H. Wines.
Okay. Well, why don't you address the irreparable harm issue, Counselor?
Well, the irreparable harm, it's set forth in the affidavit of Jeffrey Hansen. And it's more than a money judgment. We're seeking equitable relief. We're seeking to vacate confessions of judgment that are now not even permitted to be entered in New York when they're from out of state.
Well, was that statute in effect at the time this agreement was made?
No, it was not in effect at that time, but shortly after it came into effect. And like I said before, these co-plaintiffs are not even a party to the agreement. They were just added on as almost like a guarantor without their consent. And these concessions of judgment were based on an illegal contract. When counsel says it wasn't raised in the lower court, there was no litigation in the lower court. It was a confession of judgment that was signed. So this is the only way to raise usury. And we're raising usury in connection to the fact that we're bringing the action based on 5015A3, where it's a judgment based on fraud, misrepresentation, or misconduct. And the misrepresentation here is in connection to the usurious agreement. It's portrayed to the plaintiffs as a merchant funding agreement when it couldn't be further from the truth. It's not a merchant funding agreement, it's a loan. And that's how it should be treated as a loan. And that's how Judge Odorizzi treated it as a loan, because he gave a thorough analysis pursuant to Hartley versus Eagle. And he gave one of the best analysis, not because it's in my favor, but he really did. If you look at the decision, he went through every element and found in favor of the plaintiff. And the irreparable harm is they will go out of business. It's more than losing goodwill. They will go out of business. And these are innocent parties. They're not even supposed to be parties to this agreement.
Okay. Okay, Counselor, thank you very much. We have your argument.
Your Honor, one more thing.
Yes, you may.
If there's any doubt, be sent to the Court of Appeals for certification, because there's about 7,000 merchant funding agreements out there, and have different outcomes. But in this instance, like I said, Judge Odorizzi applied the proper analysis and found that the reconciliation agreement was illusory. There was no reconciliation agreement here.
Okay, thank you very much. Have a good day. Okay, 708, 709, Lynch v. South Wilson Volunteer Fire Company. Morning, Counselor.
Good morning, Your Honors. Matt Kaiser for the appellant, Donna Froelich. These are appeals from orders which denied.
We recognize we're here, Counselor. Really, this really boils down to and in all essence, the court's interpretation of fire protection district versus fire district.
Yes, Your Honor.
That's really what it boils down to. And
Yes, Your Honor. And we rely on Thykson, and we feel that the contract very clearly shows that this is a fire protection district, such that the notice of claim requirement applies, and the proposed claim did have merit. So we ask for a modification, and unless the court has any questions, we really rely on our brief.
thank you, Counsel.
Thank you, Your Honors.
Have a good day. 710, 711, Courter Longwell v. Giuliano Jr. So they can see the.
Oh, I don't know.
I wonder if they can see their phone.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Frank Rosenfield, and I'm here on behalf of the third-party defendant appellate, Seneca Meadows, Inc. And today we're here because we contend that the lower court improperly found that Seneca was not a third-party beneficiary of a contract that was made between its parent corporation, IESI New York, and Pocono, the third-party plaintiff. We also contend that the lower court improperly found that Pocono did not have a duty to procure insurance coverage in favor of Seneca, and that the lower court improperly dismissed Seneca's counterclaims for contractual indemnification. Here, there is a contract.
Mr. Rosenfield, good morning, or good afternoon, whatever it is. Good morning, I guess. Your primary argument is about the third-party beneficiary status, correct?
Correct. We believe that we've met the burden as a third-party beneficiary, but in addition, we also think that there's.
Time out. That's where you started. I just wanted to freeze on that point. I don't see that language per se mentioned anywhere in your answer or counterclaims, but if I understand your position correctly, you would say, even if it's not there, there's no prejudice to consider it because the issue jumps off the page of the agreement, because clearly Seneca is a subsidiary of the parent, IES or whatever it is, IESI. So that's your point. Thank you.
Absolutely. Sorry, there's a lag. I'm sorry, I can't tell when you're done speaking because of the lag. I apologize.
No problem.
But yes, absolutely. Seneca, when they first came in, they asserted right from the very, very beginning that there were the counterclaims that there were some third-party rights that can be construed. Pocono was named in its counterclaims. Pocono, it's not a new theory that's been advanced at any point in time. Pocono has been aware from the very beginning that there's some contract out there, whether we specifically said third-party beneficiary or not, by which Pocono owes us indemnification and the requirement to get contract.
Sir, can you assert a claim for third-party beneficiary when you specifically are asserting a breach of contract? Which is it, a breach of contract or a third-party beneficiary?
I believe that we can absolutely assert the claim as a third-party beneficiary to the contract between our parent corporation and Pocono. The language of the contract itself says that Pocono covenants and agrees to defend, protect, indemnify, hold harmless, and render the other party and then its subsidiaries and affiliates and their respective officers and directors from and against all damages, claims, demands, or causes of action. Damages.
So that's the indemnification clause. I'm not so sure that we get there unless it's established that there's an additional unless it's established that there's a breach, right?
So
there's got to be a trigger for the indemnification clause, right?
Well, right. So we're arguing that we are entitled to invoke that indemnification clause based on our status as a beneficiary to the agreement, whether it be third party or a direct beneficiary of the agreement. In the agreement,
and you say we can establish that you're a third party beneficiary as a matter of law?
So a third party beneficiary, the only thing you need to establish that is that a party must plead facts sufficient if proved to establish that it was the intended beneficiary under the contract, which I believe we did here. The pleading must set forth any basis, and that's very broad, upon which a court can construe the basis of third-party rights, and that the party must be intended to be a third-party beneficiary. And I believe the intent is very clear from the language of the contract itself, especially considering in one point, Seneca is mentioned where there's a
Well,
requirement.
yeah, that's the point. At one point, Seneca is mentioned, but it's the insurance, the additional insured section of the contract really seems to limit the obligations to Pocono.
Well, the additional insured requirement is linked with the general requirement to indemnify and defend Seneca, because if you look at paragraphs 14 and 15, they're kind of linked together there. So you read them, they should be read as a whole. So in addition, like you pointed out, Seneca is at least mentioned at one point by name with respect to the requirement to provide certificates of insurance for specific types of insurance. So I don't think the absence of the word third party is fatal in any matter. Otherwise, it would be, your general form over substance argument, which is always generally rejected by a court, and pleadings are always supposed to be read liberally. So to recover as a third party beneficiary, you really only need a valid binding contract, a contract intended for the third party's benefit, and the benefit to the third party to be immediate rather than incidental. And again, I think all of those things are clearly demonstrated. Just with respect to the immediate benefit, that would be the insurance procurement and indemnification, in addition to potentially additional funds coming from the business from its parent company in Pocono.
But again, I go back to kind of my first point. In order for the indemnification, it seems to me that in order for the indemnification obligation to be triggered, it has to be clear that there was an obligation for Pocono to name your client as an additional insured.
I think that,
and I'm not so sure that that's terribly clear in paragraph 14. I'm not sure that there's a lot that's terribly clear in paragraph 14, honestly.
Again, to that point, I would just say that the agreement is very specific in that it requires Pocono to defend, protect, indemnify, and hold harmless the subsidiaries of.
But that again is begging the question. That's paragraph 15. I'm referring to paragraph 14, the obligation to obtain additional insurance.
Right, and again, I would just say that paragraph 15 and 14, they apply directly to each other. Moreover, even if the court didn't think that that Seneca's motion for summary judgment should have been or should have been granted, we still feel that Seneca's counterclaim should have survived because third-party beneficiary liability or a third-party beneficiary theory of liability doesn't need to be pled to defeat a motion for summary judgment here. And I think there's definitely at minimum an issue of fact at least raised to third-party beneficiary status, which should go before a jury.
That may be a better argument.
So that's what I would say if the court doesn't find for the other arguments that we think at least our counterclaim should have survived in this instance and gone.
Mr. Rosenfield, let me take you to paragraph 15 real quick.
Yes.
The indemnification paragraph. Should we read those? I think there's two sentences. There's two long ones anyways, at least one long one and one shorter one. Should we read those two together? And it's a loaded question, Mr. Rosenfield, is because what I'm wondering is, should we read this to say that Pocono is required to indemnify a subsidiary, that is Seneca, but cannot do so with respect to Seneca's negligence? It's just with respect to Pocono's or its subsidiaries' negligence. Do you understand my question? Does that make sense?
I believe your question. And in there, it identifies, the contract itself defines an indemnifying party. And specifically because Seneca is not mentioned by name there, Seneca can't be an indemnifying party as to Pocono. Pocono can only be an indemnifying party as to IESI and its subsidiaries, which includes Seneca.
I'm not hung up on the identification of the parties there. I am with respect to paragraph 14. But in 15, it's pretty clear that, to me anyways, that Pocono has an obligation to indemnify Seneca. But my question really boils down to the first sentence seems to limit it only to Pocono's negligence. That is, I don't think that Pocono is obligated to indemnify Seneca for Seneca's negligence, correct? Do you agree with that?
I think I would read it more broadly because, again, it's read in conjunction with that obligation to defend and indemnify subsidiaries and affiliates from and against all damages, claims, or causes of action.
So your answer is yes.
I think that Pocono, yes, so Pocono, yes.
So, yeah, but if we read the two sentences together in 15, the answer is probably yes. That is, because the first sentence seems to say that we're only going to indemnify you for Pocono's negligence. But then the second sentence you're saying is broader than the first?
Yeah, it would broaden the obligation of Pocono.
Is that, would you say that's sort of ambiguous in that paragraph?
I think I would argue that it's clear and that damages was defined broadly and it was meant to be defined broadly, and that when you read the contract as a whole, it's clear that Seneca was supposed to be completely indemnified, or IESI and any subsidiaries and affiliates, including Seneca, are supposed to be completely indemnified as against any and all types of damages that would occur or causes of action.
Can a party as a matter of law be indemnified for their own negligence?
If it's in the contract specifically, and I think this is clear enough to show that. Plus, there's been no finding of negligence on Seneca's part, which is why I'm not sure why our counterclaims were dismissed so outright. I guess I want to bootstrap that if I have a little bit more time to.
Time to wrap it up. Yep.
So,
it's about time to wrap it up. You're correct.
Okay, so I guess I would just say that Pocono, they also claim that there's some kind of employer's liability policy that must have been met there, but the employer's liability policy isn't necessary because the decedent didn't sue Seneca. There's no finding of Seneca's negligence at this point, and the obligation to indemnify exists. So Pocono should have procured whatever coverage it was supposed to procure to protect both it and Seneca. The obligation to indemnify isn't linked to any specific type of insurance. I'm sorry if I went over my time. If there's no further questions, I will rest on my brief.
Thank you, Counsel.
Thank you.
Counselor. Good afternoon.
Good afternoon, Your Honors, and may it please the court. I guess if I could start, I'd like to start sort of at the end here, which is the relationship between the insurance procurement and the indemnification, which I think multiple justices have brought up at this point, and they are separate obligations. The insurance procurement provision, as one of the justices pointed out, is an interesting structure. I don't know what happened with it, but it came out in a very odd way. There are a couple of things I think that can be gleaned from it in the context of that paragraph. First is that workers' compensation and employers' liability insurance, Pocono had to procure that for itself. There's no statement that it was procuring that for anyone else. Moving to the next subpoint, CGL coverage does have an additional insured language in there, at least in subparagraph A2, that would refer to the company. So such that IESI would be an additional insured. That was a requirement. In that particular subparagraph alone, no mention of Seneca. The same can be said for.
You seem to be suggesting, sir, that the contract there is somewhat ambiguous.
It's certainly ambiguous, I think, Your Honor.
So shouldn't we have a trial as to whether or not Seneca was intended to be covered and encompassed by those provisions?
No, Your Honor, and the reason for that is.
If it's ambiguous, how do we avoid that?
Because this court and others have held that, much like indemnification, this is one of those obligations that has to be clearly spelled out. You can't prevail if it's ambiguous. And looking at the structure here, there's ambiguity in the clause as a whole, but there's no ambiguity as to the fact that Pocono was not supposed to procure under this agreement. There's no statement that they were to procure comp and employer's liability coverage.
How does it make sense not to include Seneca when they're the ones that's the employer? They're the ones that's on the scene. How does that make any sense?
Well, Your Honor, one way that makes sense is that Seneca should have its own coverage and that the risk was not allocated to Pocono for that. And that kind of ties into subparagraph 14B, which was just touched on, I think, briefly by the appellant. And it says, okay, the appellant had said, look, it says you go and procure insurance to cover the indemnification obligation, but it's not quite that broad.
So, but getting back to paragraph 4, though, it clearly mentions Seneca by name. It talks about performing the obligations under this agreement. It references each policy of insurance without kind of limitation. And so at least that paragraph seems to at least create a question as to whether whether there was an intention to require coverage for Seneca.
No, Your Honor, and for this reason, each policy of insurance language actually comes from the second sentence. And had the first sentence, which is the certificate of insurance language, merely says that you provide certificates of insurance for additional insured
Seneca
status.
as an additional insured, right.
But a certificate.
We know that certificate doesn't create coverage, but that's not the question here. The question is whether this contract indicates some sort of intention to require coverage, not whether there was actually the creation of coverage.
And I don't think that there's sufficient clarity here to ask to create coverage for this specific type of claim, which is employer's liability. And that comes from the fact that there's a common law negligence theory being pled either in contribution or common law indemnity. And then moving from there, and sort of, I think this harkens back a little bit, the indemnification issue, which we contend is not properly before this court for reasons that we briefed. I think if the court were to take out the motion to re-argue from the analysis, there's really nothing ever asking for indemnification. There's the initial set of papers that come from Seneca is really about insurance procurement and nothing else. It mentions the indemnity clause, but only in the context of insurance procurement. But sort of stepping all the way back to whether there's a third-party claim here, this isn't just a matter of not putting the word third party in. And I know that's what Seneca is trying to make this. But there's an affirmative theory announced in the answer. And the affirmative theory is that there was a contract with Seneca Meadows. That's not an omission. That's an affirmative statement of a theory of the case. And Seneca had mentioned some cases in its brief, Mainline specifically. Mainline ultimately holds that even an unpled theory cannot withstand summary judgment if there's an inexcusable delay. There it was years, and here it was years too. The last point I'd like to touch on, and then I will defer to the bench for any questions or rest on my brief, is the idea of what being a third-party beneficiary would be here. It's a transportation agreement for the hauling of waste from downstate to upstate. Incidental to that, it does get dumped at Seneca. Insurance procurement and indemnity aren't immediate benefits that are the subject of this agreement. The immediate benefit to IESI, the party, is that it gets to move its trash.
It's the work. That's the subject of the agreement.
Exactly. And I would just like to draw the court's attention. There was discussion in the briefing and disagreement about the import of matter of White Plains Realty. That case crucially involved an indemnity agreement. The whole agreement was designed to create indemnification. That was the subject matter. So there it would make sense that there could be a third-party beneficiary because the whole import of the agreement that was at issue there was to indemnify somebody for a loss. It didn't have a separate performance aspect of we're moving waste or any other general business. And for those reasons, Your Honor, we would ask that the court affirm, and we otherwise rest on our briefs.
Thank you.
Thank you.
Thank you, Counselor. Have a good day. 712 Wicks v. Verk.
Morning, Your Honor.
Morning, 1 second, please. Mr. Who are you waiting for? Mr. Roll? There she is. Okay, we have everybody. Let's begin. Mr. Hudson?
May it please the court. The IAS court erred in granting summary judgment in this malpractice action, Your Honors. Although it's factually complex, legally it is a straightforward one. Dr. Virk failed to make his initial burden as a movement. There was no affidavit submitted by Dr. Virk except his own affidavit. And should the court find that he did meet his initial burden as a movement in this malpractice action, plaintiff submitted adequate admissible expert proof showing that Dr. Virk deviated from the standard of care and that the standard of care was a proximate cause of the injuries sustained by the decedent. Furthermore, because this was an ER to ER transfer of Mr. Bradley, it falls within the Meduba line of cases, and it was also error for the trial court to grant the hospital's motion for summary judgment. The plaintiff's expert, should the court find that Dr. Virk met his burden, his initial burden, and again, on these facts, I would submit that he did not do so, makes clear that it was a deviation to do an intubation with a paralytic agent, given the patient's presentation, comorbidities, and status. Dr. Virk did the paralyzed intubation, and then the decedent died because of the paralyzed intubation. All of the other, and it's legion within the record, the factual disputes, and there are complicated factual points in the record of the ENT, Dr. Lee, and Dr. Virk fighting in the record, but all of that does not matter to the core of this case, which is that at the end of the day, there is a dispute, really no dispute on the standard of care, because Dr. Virk does not have an affidavit from his, in support of the standard of care on that point. And even Dr. Albert, the hospital's expert who submitted an affidavit, doesn't talk anything about the method of intubation. And so really plaintiff's expert who says, look, this is the standard of care, the method of this intubation clearly deviated from the standard of care, that's not refuted. This has to go to a trial, Your Honors. And I would say—
Well, counsel, perhaps I'm reading the record differently than you are, but I thought Virk's position was very clear, both as to causation and deviation. He said there was no injury while under his care, which is causation, and then he said, I followed good, known, and accepted standards, and therefore there was no deviation. And he says the factors that he took into account and why he felt trying to intubate this individual in the room, in his hospital room, without having the opportunity for an emergency tracheotomy would have been a violation. And in fact, it seems that he was correct. Twice this person had to have an emergency tracheotomy because, as Dr. Virk said, he thought given the swelling and the adverse reaction, the angioedema, his weight, his unstable spine, that it was the appropriate standard of care to do an attempt an intubation in the operating room. You're saying that's not the standard?
Well, Your Honor, yes, I'm saying that's not the standard. And on 2 points there, Judge, here you have a physician, and I would submit, and our brief goes into it in depth, that it's kind of a feigned issue with a physician. It conflicts in large part with the testimony in the case and the medical record in this case. But even if that does set forth—
Exactly how does it conflict with the medical record?
Well, with respect to, at least to the causation aspect that Your Honor raised, Judge, the record seems pretty clear that Dr. Virk is trying to put the patient's care on Dr. Lee at a time when it was Virk. When Virk took over the medical in this case, Mr. Bradley was cardiopulmonologically stable. His oxygen levels were good, and Dr. Virk's affidavits on the point try to put all of that on Dr. Lee and elsewhere on other people. I would submit that conflicts with the records and with Dr. Burke's.
Dr. Burke's the anesthesiologist. This person was admitted to the neurosurgery ICU. Dr. Lee's an ENT who did respond. And it appears that there were any number of doctors in here making different determinations. But what I thought was clear is that at 7:30, when he was in the OR, Burke obtained the consent for the first time, went forward with general anesthesia, and then 5 minutes later, just as he predicted, he was unable to intubate him and turned it over to Dr. Lee for the tracheotomy. Up till that point, and at 10:05, it signed out, or 10:15, he signed out of Dr. Burke's care. And at 10:39, they did the CT scan that showed there was no brain injury as a result of anything that took place beforehand. And he never goes back under Burke's care. So I don't understand the claim of causation.
Oh, Your Honor, I would submit that the causation is addressed by plaintiff's expert in depth, and that both the deviation and causation were met there. To the extent that there are factual disputes, if Your Honors find that Dr. Burke met his initial burden, then I would submit that plaintiff's anesthesiologist's expert affidavit more than raises a question of fact that would require this to be resolved by the fact finder.
Does the expert address the 10:39 CAT scan after the first surgery? Does the expert address what happened at 2 o'clock? Does the expert address as to why there probably was no brain injury if the deceased, who was not deceased at the time, had enough conscious ability to pull out the tracheotomy? He can't just say because he failed to do an awake intubation without a paralytic early on that every consequence flowed from that when other people are involved with it.
Well, Your Honor, yeah, it's the proof is that his pulse ox was at a good level at a time, and the expert ties up and shows how the refusal to do the awake intubation at a time when he was breathing normally resulted.
Which the client never consented to, the patient never consented to, and the doctor said, as far as he was concerned, based upon his opinion of what medical treatment is required in the standard, it would have been improper to try to do an awake procedure when you know you're not going to be able to do it. He's losing an airway. It's classified by the rapid response team as an airway emergency, and he sets forth the standard that he believes applied. I don't understand where your plaintiff's expert established that the standard is only awake intubation in this type of situation, particularly where the patient hasn't even consented.
Your Honor, the issue of consent, and it's all over the record. Dr. Burke, after the fact, is suggesting that the consent went to the method of intubation. At first, the patient was reluctant to consent to any intubation. He had concerns. He wanted his neurosurgeon. It's clear that he gave consent. And more to the point, Judge, Dr. Burke testified at length about what he remembered and remembered in detail this. In his EBT, he never mentioned the method of intubation. It's nowhere in the record that the patient refused the method of intubation. The patient was concerned about intubation, period. There's documents in the record that suggest.
But Burke made his recommendation based upon his understanding of his obligation to the client and the standard of care required of him. And you're saying your expert refuted his belief as to Burke's meeting his standard of care, and therefore it's a factual question.
That is correct, Your Honor. And what happened is, that when he gave consent, Dr. Burke then gave the paralyzed intubation. It's the paralysis here that was the problem. That was the deviation. It can't be that Dr. Burke says, well, geez, I did this other procedure and that's what killed him. But he refused, all methods of intubation. Our expert says clearly that it was a deviation from the standard of care intubation to do any intubation other than awake intubation by paralyzing him and giving him the paralytic agent. That's what killed him. And it's borne out by the blood ox.
Well, it certainly didn't kill him by 10:15 when he went off. Verk's care. It didn't cause his brain injury as evidenced by the CAT scan at 10:39. It wasn't until 2 o'clock that he ended up having the conditions when apparently he dislodged his trach tube. And Verk was not called back because Verk was no longer the attending anesthesiologist. Another anesthesiologist showed up, and he too was unable to do a conscious or awake intubation because of the swelling in the throat and the secretions. He did exactly what Verk said would be required and was required initially. It seems Verk got it right both times.
I would submit that that's not true, but it's a factual question, Your Honor. And the sequelae that follow from the deviation are facts to be resolved at trial. The plaintiff's expert more than adequately raises a question of fact that must be resolved at trial.
I think we have your argument. Thank you, Counselor.
Thank you.
Okay. Ms. Roll.
May it please the court, Megan Roll on behalf of Kaleida Health and Buffalo General Hospital. I'm largely going to defer to counsel for Dr. Verk regarding the merits of their motion and appeal as it pertains to the standard of care. And obviously, if the lower court decision is upheld, then there's not much else for me to say based on the vicarious liability law. But I did want to touch on the issue of vicarious liability in the event that Dr. Verk's remains in the case. At the lower court, the only thing that was argued regarding vicarious liability pertained to the Maduba standard. And I submit respectfully that the Maduba standard does not apply here for several reasons. One, it was not a patient who presented himself to the emergency department of this hospital. Rather, this individual went to the VA. The VA could not accommodate him with particular treatments that were indicated, including the MRI, including the neurosurgery consult. Had the neurosurgeons been at any other hospital in the area, this man would have been transferred to that hospital. He was only transferred to Buffalo General due to the fact that he required the neurosurgery consult, and those individuals were housed in this hospital. The transfer orders very specifically articulate that, and notably, it appears that that was Mr. Bradley's understanding because he signed a consent for the transfer. And that's in the record in the transfer orders. Secondarily, there's a sister who testified that she had communication with the decedent, and that was his understanding. He was being transferred solely for the MRI and neurosurgery consult. And then there's documentation in both portions of the VA hospital as well as Buffalo General indicating those communications and the fact that this was not an ER visit that would perhaps engage the Maduba standard. So therefore, it's our position that Maduba does not apply at all, and that it is quite clear from the record that even though the emergency room at Buffalo General houses the bay in which ambulances arrive, and that someone comes in through the emergency department by way of a transfer, does not necessarily apply to Maduba. But secondarily, there's an issue that was raised for the first time on appeal in the reply brief of counsel as it pertains to the agency and the apparent ostensible agency and the control issue. I would submit it's not preserved for the court. It should not be entertained here if you're going to look at an alternative theory regarding vicarious liability. With respect to Dr. Verk, we've established through the affidavit of Ms. Vorpal that he was an independent contractor who maintained privileges at the hospital. He was not our employee, that those privileges pertain to medical care, which as the court's well aware is based on the experience and training of the physician. The standard of law requires plaintiffs to refute that presentation of evidence with what the decedent or the plaintiff believed to have been established by the representations of the principal, which would be the hospital. Here, there's been no offer of proof in opposition to the employment relationship or lack thereof, or the independent contractor relationship between the hospital and also Dr. Verk. And as I mentioned, we established that affidavit, but also there's the consent form that was signed by Mr. Bradley indicating that he had an understanding that the individuals who may participate in his care were independent contractors and not employees of the hospital. And if you have any other questions, if you have any questions for me, I'd be happy to entertain them.
Thank you, Counsel. Counsel?
Your Honors, may it please the court, John Caniglio on behalf of Dr. Verk. First, I'd just like to point out that plaintiff in this matter only made claims against Dr. Verk specifically and Kaleida and Buffalo General vicariously through Dr. Verk. That can be found in the lower court's decision in the record on page 2142. So I think it's important when considering this case to not place any undue duties onto Dr. Verk, such as the duty of care that the neurosurgery attendings had, or the duty of care with regard to the tracheostomy procedure that Dr. Lee performed. So moving on to the meat of the case, assuming that Dr. Verk met his burden of a prima facie showing, I submit that the issue in this case is whether the appellant's expert has raised an opinion on standard of care that is sufficient enough to rebut Dr. Verk's showing. I submit that that plaintiff's expert has not. And what that plaintiff expert's opinion is that Dr. Verk should have performed an awake intubation. So awake intubation, yes, it is a possible standard of care, but when considering the totality of all the circumstances that happened in this case.
Don't you need consent for that?
Of course you need consent, and that's a part of the totality of.
Was consent ever obtained for an awake intubation?
It was not, only intubation under general anesthesia in the operating room, in the written consent.
So if Dr. Verk had done one, theoretically it would be a battery.
Correct. So yes, that's what the issue of the case is what is the standard of care.
And Dr. Verk opined as to what he thought the standard of care, what he based his decision on, and what the consequences would be. He said his recommendation was do it in the OR because of the potential need for an emergency tracheotomy. And it turned out he was right.
Correct. It was a well-reasoned consideration. You'll find case law that failures in treatment don't mean that there was a deviation from a standard of care. The point is, in this case, is that Dr. Verk.
Is there any reason in this record to believe that awake intubation in the room would have been successful or could have been achieved?
There is nothing in the record, and moreover, plaintiff's expert has not alleged such. So the appellant's expert is essentially arguing that a possible standard of care applies to this case. That's not how cases are decided on summary judgment. I'll quote briefly from the Alvarez case. In that case, the court reasoned that appellant's burden cannot be met, quote, by speculations that a defendant may have breached a possible duty of care. I think that's very apropos to this case. Plaintiff's expert has alleged a breach of a possible duty of care when that's not the applicable standard of care in this case. So I'll rely on the rest of my brief if there's any other questions.
Thank you, Counsel.
Thank you.
Nice afternoon. Have a nice afternoon. 713 Kapow v. City of Rochester.
I don't even know what
Yeah, but you can't see her. Maybe they have it in front of them. I see. Hey, good afternoon, everyone.
Good afternoon, Your Honors. May I proceed?
They're back again, so come on. Welcome back. Welcome back to the fourth department.
Thank you very much. So obviously this is a second case for Mr. Capel relating to the actions of the mayor in her official capacity with respect to her speaking out and thereby impacting his private business relationship. We believe that the lower court erred in finding that her statements made were true and thus were not defamatory, and that due to lower court's finding that they were true, there was no tortious interference with a business relationship. I realize, not to, sort of rehash from earlier, but I do think that it's important, when looking at the facts here, rather than looking at, to look at the totality of the circumstance. and look at the totality of what was stated. It certainly is. I acknowledge. I mean,
Counsel, I think your main argument is that the statement uttered by the mayor imputed an intent on your client's part to utter the racial slur, which you say is not there. And that's really the question. If we agree with that, then the motion should not have been granted.
And I agree with that, Your Honor. And to that point, I would say, again, when you read the totality of that statement, I think you look at it from this perspective of, had the mayor known the truth, that this was a flub of two words, would she be calling for him to be terminated? Would she be calling for real consequences for the news personality and the individual responsible for the slur to be no longer employed? And I think that's where the factual issue, and that's where the error for the lower court existed, which is the lower court said, well, it's true because the sound sounded like what it did. But the mayor's statement certainly...
Right. Counsel, you're saying it sounded like what, no one's disputed what the words were.
Right.
What we're disputing, and I understand, Your Honor, I mean, and I'm not trying to say I'm disputing what it sounded like, but I think it is important. It's certainly important for Mr. Capel, who, I mean, listen, here's the reality. It's a lot for someone to be accused of uttering a racial slur. That's a big deal. And for him, it's really important to just make that distinction. Understandably, it would be important for me too, to make the distinction of, I didn't say a racial slur. It may have sounded to people like that because I meshed two words together, but I didn't and would never voluntarily or involuntarily say a racial slur, so I understand, Your Honor, and I'm not disputing that it could have sounded to people that way. And
Mr. Ricotta, that takes us back to Justice Peridotto's question again. So the key issue here is if she alleged intent, then we may have to reinstate the complaint.
And I think that's true. And I think here there's no question the mayor just spoke out, got some, went out there, cameras, tried to score some political points at the detriment of a private citizen by just calling for his termination without doing any baseline cursory determination as to whether there was any.
So before she can call for his termination, because in her opinion, his comment was racial, you're saying she has to investigate as to his intent in that comment?
I think as the mayor, when you're speaking out and calling for the termination of a private citizen in his private employment, I think you have to do more than just react and just say this person, what implications are this person is a racist, they uttered a racial slur, they should be fired. If the mayor didn't think he did anything intentionally wrong, then logically, she wouldn't be calling for his termination. So her statement as a whole, broadcast to the public, is condemning Mr. Capel and impacting his private employment. And I think that's wrong. And that's an overstep of what the mayor's role and responsibility is. And I think for that reason, the judge should have denied the motion to dismiss and allowed further discovery to understand what the mayor knew, why she said, why she chose to speak out in the manner that she did on private employment. Thank you.
Counselor?
Good afternoon, Your Honors. Patrick Beath for the City of Rochester and Mayor Warren. The bottom line here is that the Mayor Warren's statements were true statements or statements of pure opinion. She reacted to what she heard Mr. Capel say. She reacted to what she heard WHEC broadcast, and that's what she said. And we have Mr. Capel.
And your argument is that it doesn't matter whether he said it by mistake or with intent.
That is correct. That is correct. And the statements attributed to the mayor do not have her opining that it was his intent to say those things. She says that WHEC aired a racial slur uttered by one of their broadcasters. We have Capel admitting that what he said sounded like a racial slur and that he was aware of the racial implications of that. So I don't think there's any issue here, really. It was a true statement and statement of pure opinions, and those are not actionable. Unless the court has other questions, I'll rest on my paper.
Thank you both. Have a nice afternoon.
Thank you.
714 Halleback v. Berry.
morning, Your Honors.
Morning, counselors. Mr. Graff, you may begin.
Thank you, Your Honors. May it please the court, Kevin Graff on behalf of the defendant's appellants. This is an appeal from a motion for summary judgment that was improperly denied by the lower court. And the gist of our arguments, Your Honors, is that there's a gap in treatment which requires dismissal of the plaintiff's complaint. Obviously, the Court of Appeals has held that while a gap in treatment is not dispositive, it can lead to a dismissal of a case if the gap is not reasonably explained by the plaintiff. I obviously
was
cited
evidence of some therapeutic intervention, wasn't there? Was he apparently taking prescription medication during that time period?
Your Honor, Justice Joseph, I'll get right into that. The evidence submitted was that a primary care doctor in the first year, there was only 3 visits in the first 2 months and then a 1-year gap. In those first 2 months, there's records from a primary care doctor indicating he was given medicine, a prescription medication, nabutitone, which I'm probably not saying properly. But the only evidence we have that medication was ever, well, there is no evidence that medication was ever taken. There's evidence it was filled once. We have, the prescription bottle that it was filled once. There's no affidavit from the plaintiff that he actually took the medicine during that time.
Didn't he say he was taking it? Didn't he say in his deposition that he took the medication?
There's no direct evidence in the deposition that he took the medicine during this 1-year time period. There's mentions in the deposition that he was prescribed medication and took them, but that's laid out more in my reply brief, Your Honor, Justice Perodato, that that testimony was just more about where he filled the medication. And then there was more direct testimony about him taking the medication in 2017, years after this gap in treatment. There's no testimony in this record that he was taking this medication as his sole course of treatment during that 1-year time period. So it's our position that, the plaintiff is obviously not trying to reasonably explain the gap. The plaintiff is trying to say there is no gap. And I just think in the record before this court, there's no evidence that he was actually taking this medication. The plaintiff could have very easily submitted an affidavit as part of the motion saying, yes, I was prescribed medication. I took the medication for a year. If that were in the record, I would probably have some pretty shaky grounds, but it's not. We have a doctor's note, a primary care doctor's note of him being prescribed this medication, and a photograph of the bottle showing he filled it once.
Plus, there was some testimony, as Justice Perodato indicated, that he was taking the medication.
There is testimony.
Is that enough to raise the question of fact here?
It is not, Justice DeJoseph, because the testimony is not about taking the medication during this year gap in treatment. The testimony is about taking the medication years later, more around the time of his deposition, which wasn't done until 2018. So
you've pretty much just focused in on that 1 year, no evidence in the record, deposition, affidavit, or otherwise that establishes that any of this medication was ever consumed, taken within that time frame, possibly after a later date, but not during that, and therefore that addresses the gap in treatment argument.
That's it, Your Honor.
Okay, thank you very much.
Thank you.
Good afternoon, presiding Justice Sentra, members of the Fourth Department. I don't want to lose sight on the fact that the burden is on the defendant here, and it's a shifting burden, as the justices are aware. In the first instance, the defendant, the appellant, has to demonstrate that there was a gap in treatment, and he is required to promote that with evidence that's based upon the record. The total evidence, when read together on this record, justices, tends to show that plaintiff took medication from his initial consultation with his primary care physician. It can be found, around page 247, 248, and 9 on the record of appeal. He's taken medication from that point in time, prescribed by at least his primary care physician, up until the time of his deposition.
In 2018.
Exactly.
So that covers the gap year, which is from July of 2014 through July of 2015, right?
We believe that's true, Justice Perodato, and I appreciate you saying that, because what the appellant has done here is they've tried to focus in on a very narrow, and what I would consider what they define as a gap, but it's really not even a gap, because like I said before, all the evidence in the record demonstrates that the plaintiff did have some type of treatment. I'd like to refer the court to its recent decision. I guess it's a 2016 decision in Cook, where this court specifically stated that the record, and this is the quote from that opinion, the record fails to establish that plaintiff in fact ceased all therapeutic treatment, end quote, during those purported gaps. So according to this court's own language,
You're saying this situation is no different. This falls within that language of Cook.
Exactly. Thank you, Your Honor. And the defendant is required to demonstrate that in the first instance before the gap or the argument even shifts, or the burden shifts to the plaintiff to come up with a reasonable excuse for any perceived gap. Now, the cases that defendant has submitted deal with where a plaintiff had no treatment whatsoever up until a certain point in time, say 12, 16 months following the event. And then also cases where there was an allegation of plaintiff's pre-existing injuries. We have neither of those situations here. So it's our opinion that the defendant's cases are inapplicable in this.
In essence, they failed to meet the burden because they put the proof in.
That's our primary argument, Judge, and I don't want to lose sight on that. And the other thing that I found interesting here, and it wasn't necessarily made a major point in papers, but I think we've talked about it at least tangentially, is the fact that that the defendant can't actually use the July 28th, 2014 date as the measurement date for its alleged gap in treatment. And the reason I say that, Your Honors, is because the doctor, plaintiff's doctor on that date, diagnosed plaintiff with neck pain and muscle spasm. Muscle spasm, of course, is an indicator of serious injury. But beyond that, it specifically reads on the record of appeal, page 249, the doctor's plan, as he describes it, was to increase Flexerol to 10 milligrams at night and also prescribe Nambumentone 500 milligrams 4 times a day as needed. And, in the papers, it describes what those medications are for. It's for muscle spasm and relief of plaintiff's, complaints. But, it's not coincidental that the doctor describes that as his plan and leaves nothing else in there. He doesn't describe plaintiff needs to attend physical therapy. He doesn't describe that plaintiff has to go to a neurosurgeon. He doesn't describe that plaintiff should endeavor in these other types of therapies. His treatment course of plan at the time was solely relegated to prescription medication use. And on the following page of the record of appeal, page 250, he gives the plaintiff multiple refills of these medications. So defendant's appellant's argument that this gap in treatment occurred beginning July 28th, 2014 is really misguided, because clearly the doctor intended this therapeutic treatment regimen related to the medication to begin on that date, not to end his treatment of plaintiff on that date. So that's a huge distinction, I think. It really lends a lot of credence to, and it underpins plaintiff's arguments that the defendant has not met its burden here. Beyond that, the plaintiff did testify that he did take medication, and in fact, he was taking medication in his deposition some years later. We have an affidavit from plaintiff's treating Dr. Capicato that clearly indicates he has indications of serious injury. We have the Pommels case and the Cook case that I described.
We're familiar with the record.
I'm sorry, Your Honor, and I will move it along. As I stated, you know, and there's some mention in appellant's papers about how, you know, plaintiff somehow failed to tell them that he was taking medication. Well, first of all, I don't think the record bears that out, but even if it does, I believe those arguments are also misguided because defendant appellants had the opportunity at plaintiff's deposition to ask him directly the question, did you?
Well, and he testified he was taking medication. We've been through that, yeah.
And we're kind of splitting atoms, I think, Judge Perodato, trying to really winnow down some, you know, alleged gap in treatment when there's really no record of any gap in treatment here. And we can't even come up with initial date that the defendant.
We go back to the same process. His moving papers, he put the proof in. Proof doesn't establish that there's any gap whatsoever, so therefore he never met it.
That's precisely true. And if this court is inclined to, you know, buy into appellant's arguments, I would also look at Letty's report that the defendant submitted. And Dr. Letty actually opines in his report that plaintiff did sustain an injury. He doesn't call it serious, but he says he sustained a strain type injury, which this court has said can qualify as a serious injury. And that also, and these, you know, items can be found in appellant's reply to our original moving papers. Dr. Letty, on page 336 of the record of appeal, Dr. Letty says that plaintiff sustained a cervical muscle strain that resolved within a typical time frame. That's indefinite. I don't know what that means. It could mean 90 days. It could mean 180 days. It could have meant up until the time that Dr. Letty did his records review. And moreover, Dr. Letty never conducted any range of motion testing. He never really established anything, you know, in the plaintiff's opinion that could refute plaintiff's qualifying injuries that are alleged in its summons and complaint bill of particulars. Judges, if you don't have any other questions for me, I'll rest on that.
Thank you. Have a good day.
This court will stand in recess. Dine.